Any mention?
I'm praying for one matter to be listed tomorrow. It's regarding those tender matter which pertains to the supply of food grains in ICDS. Lordship had granted had passed an order whereby the respondent were directed to pass an order on my representation. That liberty was granted to me.
The position has been disposed of.
Not disposed of. Not disposed of. And on top of that, they had issued a corrigendum. Now, certain conditions had been improved by them.
What corrigendum? You want to mention, but it's a pending petition.
Pardon?
Pending petition disposed
It's already disposed of, Your Lordship. Now they have issued a corrigendum. Now they have changed the conditions. Now two conditions are left. Now we are challenging those conditions, Your Lordship. The last date is on 25th, tomorrow, Lordship.
May I get to mention item number 36. Lordship, I beg to mention item number 36.
Yes.
Lordship, kindly adjourn this matter for today. Your Lordship, the conducting council has some personal difficulty, Your Lordship.
36.
Yes, Lordship. Kindly adjourn this matter for 2 weeks, Your Lordship.
2 weeks. Yes. Yes.
May I please, Your Lordship?
May I have a fan?
Item number 22, Your Lordship. May I kindly pass over to
Yes.
next week. Item number 22 of the hearing list.
You pass over items for a day only, not for 1 week. You adjourn matters more than a day. You just pass over only for a day.
No, Your Lordship.
You're a seasoned lawyer, you should know that. Pass over means for a
It's a
day.
personal difference. Next week, Your Lordship.
Adjournment, no, you don't understand what I'm saying.
Passover means?
You pass over means only for 1 day.
Next one, yes.
You adjournment, you ask
Yes,
for
yes.
more than 1 day.
Yes, Your Lordship. My apology,
20?
Your Lordship.
No, nothing,
22.
just that.
22.
I have no objection. This several times you have been asking. I
2
have
weeks,
no
yes.
objections. Next week, Your Lordship.
2 weeks, yes, Your Lordship.
Next week, I think it's a bit difficult.
22 matters, Your Lordship.
2 weeks too. Stretching too far.
Yeah.
Much obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 30. Your Lordship, the case jury session will be coming up sometime in the month
Which
of...
one?
Item 30. East Autumn.
What's the matter about?
It's regarding...
Rajuni?
What's the matter about?
Your Lordship, it's regarding...
Are you sure?
East Autumn.
East Hotel.
What's the matter about? You don't know what's the matter about?
30.
What's the matter about?
No, he does not know, Your Lordship. He just under
No,
instruction.
it's his chamber. He should know.
Yes, Lordship.
Item 30.
Don't mention if you don't know the matter. Sit down. There's someone. Let it be called out. I'm tired of this. Look, you need to look at the file. Yes. Anyone else? It's too much sometimes. You think it's a given that you just can't ask for time that it's allowed. As it is, this court, it is very good to lawyers. I don't shout anything, but sometimes the juniors, it's getting too much. No one reads the brief also. You don't know what the matter is about. Yes.
Please, Your Lordship, I beg to mention item 32.
Yes.
Lordship, on the last occasion, we were given time to file affidavit within 2 weeks. But I'm praying that Your Lordship allowed us to file today in the course of the day. The affidavit is
hearing
ready.
list?
Yes, Lordship, it's listed for hearing today.
The affidavit will be filed in the course of the day, just after 2 weeks. Yes.
Hello,
Yes.
Main list, item number 1.
Yes.
Lordship, in this matter,
Where's
we
Mr.
have,
Haraiso?
he's on legs, Lordship. Lordship, in this matter, we have received their counter affidavit. I'm praying for 2 weeks' time to file our rejoinder.
Your Lordship, we've already filed the affidavit, Your Lordship.
What do you see in the affidavit? Oh, the very big affidavit. This one?
Your Lordship.
Yes, let's see. Iwan Yang. Praise funds allowed 2 weeks' time to file a rejoinder affidavit filed by the respondents list after 2 weeks.
Are you obliged?
Item number 2. Your Lordship, I'm praying that if this matter may be taken up after some time, Your Lordship, as learned DSG is its own legs.
This has become no one knows what to do.
In fact, my lord, now they have given a new policy which is in direct contravention of the orders passed by this honorable court. The contempt is complete now, my lord.
Then you
Let them place the policy, my lord. I'll show
you bring out record.
The policy is with them. It just came up day before yesterday.
Do you have a copy with you?
As of now, I have it on my mobile. They give me a copy. I'll try to take a printout. They have stated what the writ petition was closed on a certain commitment before this court. They have directly contravened that commitment before this court.
Another matter, like a similar matter also.
Yes, of another doctor. They had allowed him to. They had transferred him to BSF.
No, now they allowed him to join because
yes,
under threat of contempt.
Now, what they have done is the commitment before the court was that GDMO with specialization and the already specialist doctors would be held at par for postings. Their present the policy that now they have brought in specifically states that they will not be held to be equivalent in postings. So that is an exact contravention of the orders passed by this court.
Let him come.
I'll just try to get that.
Yes.
Item number 3.
Lordship, 3 and 4 are connected items. In item 3, the respondents has filed their affidavit. Now in in item number 4, Your Lordship.
Have you filed affidavits? Have you all filed affidavits now?
Already filed the affidavit.
Then you file rejoinder.
Lordship, in item 3. Now in item 4, some of the private respondent has not filed the affidavit.
First mistake was item number 3. 3 is complete, all the affidavits.
Yes, only I have to file my rejoinder.
Yes, item 3 only record. Mr. M. Nopur, please, my lord.
My lord, small prayer, my lord. In item 3, my lord. The one order is passed, my lord, on 5/9/20 last occasion, my lord.
Yes.
In item number 4, my lord.
Yes.
With regard to the salary, my lord, release of salary. Since are connected matter, in item 3 also, my lord, humbly pray, my lord, same order may be passed, my lord.
Let's go item 4.
Because they are pursuing with the now department for releasing their salary, my lord.
You also a teacher?
My lord.
You're not in this case. You're for 9 and 10.
My lord, in item, my lord.
Number 4 is for 9 and 10.
Yes, my lord. 9.
Then?
My lord, in item 3, my lord. Nashiruddin, my lord. 8 and 9, my lord. I pray for similar order, my lord.
8 and 9. 8 and 9, you're Ruchi Kumari.
No, my lord.
Item number 4 is my client.
Okay, you're 9 and 10. 9 and 10 is Abdul Hakim and Abida Hussain.
Yes, my lord.
Okay.
And in item 3, Nashiruddin, 8 and 9, my lord. I'm praying for item 3, my lord, Nashiruddin, my lord.
Okay. Mr. Emal Nongpur submits that prays that he will allow 2 weeks time to file affidavit to the rejoinder of the affidavits filed by the respondent staff. Mr. S.K. Hassan submits that as the case suddenly situated with WPC number 425, wherein an order was passed on 5/9/2023, wherein it had been made clear that if the respondents are entitled, penalty of the writ petition shall not stand the way of the respondent manager committee paying their salary stop. Accordingly, it is directed likewise in the incident petition with regard to the respondents number
8 and 9.
8 and 9, yes. That's up to 2 weeks, yes. And number 4?
And number 4, Your Lordship, respondent 5 and 7.
Not who's of 5 and 7? You have not filed.
I require another 2 weeks, Lordship.
Why?
Last time, 7
7 who? Where may they keep you for a charge? 7?
No, sir.
7? Who's 7?
KP Bhattacharya.
No, where is he? No one's there on his behalf. Mr. S. Pandey, the counsel for 5 days for further 2 weeks time to file affidavits. Praise granted. None appears for respondent number 7. Has an affidavit been filed also, I think? What file? 7? Yes, 7 and no affidavit is on record. So let's up to 2 weeks.
Item 5. Item number 5.
Lordship, here the respondent number 5 has yet to file their affidavit.
Yes.
Lordship, I'm here on behalf of respondent file. Your Lordship, I'm praying for further 3 weeks time to file affidavit.
2022 matter.
I just entered appearance on the last occasion, Lordship.
No objection.
No objections, Lordship.
You file your wakalat.
Your Lordship, basically,
No, there's a ministry, my lord.
Ministry.
Ministry.
Yes. MS somehow praise funds allowed further. You file your affidavit state.
My lord, we have already filed in the month of June. In the month of June, we have already filed.
MS Esram Thao for respondent number 5 praise funds allowed for a 2 weeks time to file affidavit. This start thereafter on so and so.
Item number 6.
Yes. Start.
Lordship, I pray the matter may come at the end of the board, Lordship.
End of the board?
Yes, Lordship.
You ready? Today is for hearing on what?
Framing of
Framing of the
issue.
You file your suggested issues?
No, Lordship.
Have you been filed or not? Have you filed them?
No, Lordship.
Then you file them first, give a copy to them, they'll have a look. And the poll. 24? Yes. You already filed it.
I have no very Lordship.
You have no idea.
No, Lordship.
You should have idea. This court won't. You see, it tries to give chance to juniors, but if juniors don't take the opportunity to argue and to read the files, very sorry. It's been filed or not? Don't recall that. You're for the petitioner.
Yes, Lordship. Has been filed, Lordship, on as per the order 24th.
Not filed. What's filed? It's been filed. Yes. You got copies, correct?
No, it was not supplied to us.
Not supplied to us.
You supply copies.
Yes, Lordship.
Yes, the matter is fixed today for framing of issues by the court. Stop.
Lordship, I pray the matter have the bottom of the board, Lordship. Mrs. Tapai have some submission to be made, Lordship.
What submissions to make? Tom. However, the counsel for the respondents have submitted that a copy of the suggested issues filed by petitioner has not been supplied to them. Accordingly, counsel petitioner directed to supply a copy of suggested issues. We listed after 1 week. It's not for 1 week, yes.
Item 7.
Lordship, I have entered appearance today. We require some time to file our response.
How many respondents are there?
One.
Mr. Vichke Gatan is counsel with yes, entered appearance on behalf of the respondent and prays that we allowed 1 week's time.
It's too short, Your Lordship.
10 days time.
At least 2 weeks time.
2 weeks time, okay, to file reply. Yes, thereafter and so and so.
Item number 8.
Filed, my lord.
Yes. What affidavit did you file?
This is, my lord, with regards to the service of the private respondents, my lord.
What is this, Dr. Mojika?
Just file rejoinder, my lord.
No, rejoinder, my lord. It is an with regards to the.
Wait 1 second. Yes, rejoinder affidavit. Is it a transfer matter?
Yes, ma'am.
You got a copy?
Yes, ma'am. Come for hearing.
You have prepared, let him stay in the same place. Transfer has not been effected. It's an interim order operating.
Well,
Yes, Vari submit that the proceeding is complete. Only is a matter for hearing. The interim order pass shall continue until further orders.
Hello.
Yes.
Item number 9.
this matter has become infatuous. We have passed an order
May I please
whereby
check?
their grievances has been addressed. I don't think so now they should have any more grievances.
After some time, Lordship, conducting counsel is engaging in another court, Lordship.
He's where?
Engaging in another court.
Where? Which? What's the order?
The order?
In the affidavit.
No, Your Lordship. They have just recently passed on 4th of September.
You have a copy of that?
Yeah. They have supplied us. They are very much aware.
Yes. Okay.
So whatever grievances he had is sorted out now.
You have anything more to say? We want to wait for Mr. P.T. Sangma to do the last rites. Yes. Okay, after some time.
Okay, Lordship.
10.
Titan. This is.
What is this?
Established, Lordship.
Who's number 2? You file additional affidavit?
Not yet, Lordship.
You won't file it?
We will file it.
the
Some more
matter
time,
about?
Lordship. It's selection and appointment, Lordship.
Lordship will recall the petitioner's appointment was fraught with a lot of anomalies where the selection committee had not even assigned their signatures. That's the same case.
Some more time,
What
Lordship.
additional facts are there?
I want to construct.
Anyway, so she's a GT Sangma.
GCH, madam. GCH,
Sorry,
madam.
GCH. Ambassador principal is allowed for the 2 weeks time to file after bring on record additional facts. Yes.
11.
My lord, here the affidavit has been filed by the.
What about service and the other respondents?
My lord,
7, 9, 10, 11?
I have filed an affidavit, my lord.
They all been served?
Yeah, it has been served. The postal receipt is already there, my lord.
Office note indicates that after service has been filed by the petitioner being record the factum of service on respondents 7, 9, 10 and 11. Yes, after it's been filed also, you file affidavit. Yes, Dr. Mbuzika submits that affidavit on behalf of the respondents number
1 to 6.
1 to 6 has also since been filed. So this is matter for
file rejoinder, my lord.
For rejoinder. This is matter for 2 weeks for rejoinder for appearance of the other parties. Yes.
12.
This
Yes.
matter will be disposed of on the basis of the affidavit.
Affidavit.
State.
You file our affidavit, my lord.
This is that matter, my lord, where end of last year, the petitioner who's a doctor, who's a dentist, which was transferred to Garo Hills. Lord, we came before your lordship, Lord, stating that her son is suffering from autism spectrum disorder. During the pendency of the writ petition, my lord, government had considered, and in January 2023, I was posted here in Ganesh Das. Now, within 3 months, my lord, a fresh order comes where I've been transferred to Jonksha and deployed in Ganesh Das. Therefore, I've come by way of this writ petition. Now, they have filed an affidavit stating that it is because of a technical problem. I am grade 3. I belong to grade 3, my lord. While the post which is available in Ganesh Das is a grade 2 post. Therefore, to overcome that difficulty, they have now posted me in Jonksha and deployed in Ganesh Das. So, because of this difficulty and technicality, my lord, I will not press. But some assurance should be given that I should not be disturbed, my lord, frequently. That is number 1, my lord. Number 2 is, my lord, with respect to the salary.
Yes.
I'll just indicate, my lord, page 2 of the affidavit filed by them. Para 6, this is regarding the post, grade 2 post and grade 3 post. Para 6, my lord, page 2. In terms of this statement, my lord, I will not press my petition with an assurance that they will not disturb me, my lord, frequently. The second point is, my lord, regarding my salary, your lordships may kindly have page 11. Page 11, this is letter dated 16th of June 2023, after the writ petition was filed. So the reason why I have not been receiving my salary for the last 20 months is due to some discrepancy in my leave. So by way of this letter, they state that they have now clarified the position of my leaves. So, my lord, if an assurance on this also can be given that within 2 months they will release my salary, that should suffice, my lord.
Anything to say?
Lordship, with regard to the
Salary.
no, my lord, the prayer for transfer that he should that she should not be disturbed. There we cannot make any assurance, my lord.
Frequently.
That assurance cannot be given. It's a transferable post, lordship.
Yes, yes, of course. Court can't give.
That is why, my lord, assurance from them.
We will
Yes,
give no
I'll
assurance,
take
lordship.
down. Yes, the petitioner had come before had come before this court being aggrieved with transfer and posting order dated 22nd May 2023, wherein she stood transferred from Ganesh Das government, then capital M and CH capital Hospital Shillong, to Jongsha JONG PHC East Khas Hills against an existing vacancy, but to be deployed in Ganesh Das Government MNH Hospital Shillong. Stop. Today an affidavit, today an affidavit has been filed wherein the state respondents have indicated at para 6 that the transfer and posting order was made not to dislocate the writ petitioner, but was to overcome a technicality. Stop. The said paragraph being relevant is quoted here in below, para 6. Stop. Further grievance raised by the writ petitioner with regard to the non-receipt of her salary, which she claims has not, next paragraph, has not been paid for the last 20 months. In this context also, the state respondents have clarified the same by way of a communication dated 16/6/2023 from the respondent number, DHS respondent number.
About 5 minutes.
Number 5 to the was commission issued by the respondent number 5. Stop. The said communication indicates that the non-payment of the salary the non-release of salary was due to the fact that the leave applications or the leave taken by the writ petitioner were yet to be reconciled. Stop.
Due to COVID, my lord, at the bottom.
To reconcile, as the periods were during the COVID-19 pandemic. Stop.
Lordship, this pertains to leave application, Lordship.
Yes.
Not
Yes.
salary.
This affects the salary.
It affects the salary
Lordship.
because they have to reconcile with the leave.
Lordship.
Yes. Next paragraph. After hearing legal counsel for the parties, and I've examined the materials record, especially the affidavit. In the considered view of the court, nothing remains for consideration. Nothing remains further for consideration, and the same is hereby closed. However, with the observation that the salary of the writ petitioner be released, the salary due to petitioner be processed and released as expeditiously as possible. Yes.
Much obliged, Lordship.
No.
Item 13.
Your Lordship, the respondent has yet to file their affidavit here as well.
What's the matter about?
It's regarding regularization, Your Lordship.
Yes.
My lord, I pray for further time.
Yes. 20, okay, yes. MSZE, sorry, not the inorganic MS. ARC only pays for not further 2 weeks' time to file affidavit. This thereafter and so on. So
14.
always be up with your briefs when you appear. Yeah.
Lordship, the respondents have filed the affidavit.
Which respondent?
Respondent 1, 2, and 3.
Sangma for?
Warrant for 2 and 3, my lord.
2 and 3.
Okay. Number 1.
Lordship, I'm appealing for respondent number 1.
You file the affidavit?
Already filed.
If I submit, my lord. My lord, if your lordship.
1 second. You don't need to file the rejoinder to number 1.
Lordship, I have required.
Yes.
That's mine.
My lord, here in my affidavit, my lord, I have order to enclose the translated copy, my lord, to my annexure.
I can't hear you.
My lord, I pray that the lordship may allow me to take necessary steps, my lord, to enclose the translated copy.
You have not given a translated copy?
Due to bona fide mistake, my lord, I forgot to.
How did the registry accept it? You can make a note. By number 2, right?
Number 2, Lordship.
26.
Last page, my lord, annexure E.
Annexure
E, my lord, page 18.
Oh. Yes, the respondents counsel upon submit that they have since filed the affidavit. Stop. However, Mr. C. Changma prays that he may be allowed to file a translated copy of Annexure E to the affidavit filed by respondent number 2, which is a letter dated 5th July 2023. He submits that due to inadvertence, the same was not filed along with the affidavit stamp. The prayer is allowed. Translated copies of the letter be filed within.
Course of the day, my lord.
Within?
During the course of the day.
In the course of the day. Stop. Make paragraph Mr. M. Longpur prays for and is allowed 2 weeks time to file a joint affidavit filed by respondent number 1.
1, 2, and 1.
By the respondent. Yes.
The interim order. Lordship, the interim order. Maybe.
Is it interim order?
Lordship.
The interim order shall continue till the next year.
Item 15.
My lord, the respondent is yet to file their affidavit. Respondent is yet to file their affidavit. And as per the last order, my lord, we have written to the post office for verifying the service report of respondent number 5, my lord. So we are awaiting the response from the post office, my lord.
Awaiting instructions, Lordship.
MS Njishra, Senior Government Advocate, praised funds allowed for that. How much? 3 weeks time?
Lordship.
To obtain instructions to file affidavit. Stop. Ms. S. Day, counsel for the petition submits that they serious report of service of notice on respondent 5 still awaited. According to this matter after 3 weeks for affidavit and for service report on respondent.
Much obliged, Lordship.
Item 16.
My lord, we are entering appearance.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of respondent number 6, so
Yes.
I may be allowed for 2 weeks' time to file my affidavit, Your Lordship.
You already were given time last time.
Your Lordship, we had just entered appearance in the last week, Your Lordship. On the 11th of September, we have filed our power, Your Lordship.
For number 6.
Yes, Your Lordship.
Nazari is not appearing anymore.
No,
Who's
we
Mrs. J. Nazari?
She is my friend, Your Lordship. We are
Yes, together.
Yes, sir.
Then this order dated 23rd of August. MS J. Nazari, counsel for responsive praise, should be allowed to file a power or affidavit before the next date.
So we happened to get the power only on September.
Okay.
My lord, on behalf of the state respondents, I'm still waiting for
1,
instructions.
3 and 5.
1, 2, 3 and 5.
Lordship, instruction I've received, we'll be filing on before the next date.
Okay. As paid, response granted further 2 weeks time to file affidavit thereafter. Anything? No urgency? Okay.
17.
Hey, page ni. Cái tình thôi xong qua, xong mình. Chúng đi lạnh cái này page. Yes. Yes, affidavit. File.
1, 2, 3. We have filed it.
1, 2, 3 has been filed. What about 4 to 17?
I'm waiting for further 2 weeks' time to file my affidavit. I'm appearing on behalf of 4 to 17.
Where's the petitioner? None appears on petitioner. Officer indicates that affidavit is in opposition has since been filed. Behalf of 1, 2, 3. Stop. Next. MSC Union for respondents 4 to 17 praise for. And so 2 weeks time to file affidavit. Yes. Just thereafter and so on.
18.
Lordship, here I pray for some time, Lordship. After 2 weeks' time, Lordship.
As prayed for the 3 weeks time allowed for affidavit by respondents.
Hello.
19.
I am, Your Honor, I am appearing for respondent number 2 NIS.
Which matter?
Item number 19, sir.
Respondent number 2?
Yes, actually, respondent number 2 is the NIS and I am representing the director. NIS.
1 second. What's the matter about?
This is regarding the non-issuance of the pass certificate, Lordship.
Oh, NIS, right. Okay,
Sir, Your Honor, I was supposed to issue the pass certificate, but as per the verbal instructions, there is some confusion that whether actually the student will pass or not. So for that, we have sent a requisition to the headquarters to verify my marks and all.
you file your affidavit, you file whatever, you file affidavit. You file your affidavit, yes. His name is Milan Laskar. Yes, he's appearing. Yes,
I'm from 41.
Yeah, Doctor, what's your name? Milan, not Doctor, Milan Laskar. Milan, what's your name? Milan Laskar. What's your name?
Yes, sir. I am Milan Laskar.
Okay. Milan Laskar, Sri Milan Laskar entered appearance behalf of respondent number 2 today and prays that we allowed further time to obtain some instructions for affidavit. So, what about 4 and 5? Nothing to do.
The whole of the state was limited, we are permitted, we have allowed the application subjected to the submission of the certificate.
Are you filing affidavit?
I don't think so, because
You also
there is
won't
no
file.
appeal against us.
Dr. Mbozika for number 1 and Alkoni for 4 and 5 submits that as they are formal parties. No appeal will be forthcoming on their side. List after 2 weeks. 2 weeks, Mr. Laskar, for affidavit for instruction stroke affidavit. Yes.
Item 20.
May it please your lordships.
File
My lord,
the
this is the Weybridge case. Yesterday, my lord, late afternoon, a copy of the affidavit was found on me, my lord. Now, my lord, for me, everything is at stake, your lordships. Yesterday itself, my lord, deadline is 30th, your lordships. So everything is at stake, your lordship. I prepared an affidavit yesterday itself, my lord. Now it is in the process of being filed, your lordships. So this is the only thing, your lordships. If it can be taken up towards the end of the board.
30th? 30th last 3rd September.
30th September is the deadline.
You have enough time. Now we only on the. Today is the.
My lord, here is the case. What happened, your lordship? An agreement was.
You have no right,
no,
Mr. Sen.
my lord, whatever it may be, my lord. Here is the case, your lordship. Lordship need to decide it, my lord. Whatever submission I
Yeah,
made.
I mean, the thing is that you also have just on the basis of of this. The court is not very happy with your renewal. That was that we expressed last time.
I'll try to explain.
You have to satisfy the court that the renewal was above board and bona fide.
I'm asking for only that opportunity to satisfy your lordship.
Of course, you can't.
If your lordship is not satisfied,
we can't shut you down. We have to make a
my lord,
case.
my only prayer, your lordship, either towards the end of the board or my lord, positively tomorrow.
We'll have it on Monday.
My lord, that will be too late, your lordship. Why I am
Monday is 25th.
25th, your lordship. My problem, your lordship will hear the matter. Lordship may take some time to pass the order. My lord, at least, my lord, I should have the opportunity, my lord, to appeal, my lord, the intercourt appeals and other things, your lordship.
Oh, you're already thinking that this
no, whatever, my lord.
See, if you come in that preconception, then Monday. This is a matter on Monday. Yes, I'm very sorry, Mrs.
My lord, let it be tomorrow, your lordship. Let it be tomorrow, my lord.
You already come to preconception that.
No, my lord. In case my lord rejected, my lord, they said I should have the fair opportunity.
Yes.
My lord, senior counsel is leading us in this matter. Mr. Paul is here. Mr. Paul is leading.
Well, Mr. Paul, if you come to the phantom, you will see him also. Mr. Paul, you've heard of the ghost who walks. Yes.
Well, they filed an affidavit pursuant to your lordship's orders. Now, two very interesting things emanate from this affidavit.
Where's the affidavit?
If I may recall, this is the counter filed by them. I think it was filed on the 15th September.
Okay. Yes.
If your lordship can have paragraph 3 at page 2.
Yes.
I'll just read the first portion. It says that the deponent states that while the subject bit was at the TC evaluation stage, I think that would be like technical evaluation stage, the petitioner had preferred the aforesaid writ petition. This is the earlier writ petition that your lordships were dealing with. Since the matter was sub judice in the Honorable High Court of Meghalaya, due to the writ petition being filed by the petitioner, the TEC went to examine entire bid documents in a more deliberate manner in order to scrutinize the documents submitted by all the 7 prospective bidders. Now, here they say that an email was sent by them.
Where is it?
To the OEM. The subsequent part of this paragraph.
Yes. Where I don't see where's the email. As per MPOG.
If annex the email subsequently.
Okay.
Now, the point is, if I'll take your lordships to the relevant portion. At paragraph 8,
yes.
If I may read, the defendant states that so-and-so cancelled their authorization to Pragati Engineers by letter number so-and-so dated 1st August 2023, which was forwarded to the respondents in reply to the query raised by the respondents through their email dated 11th August 2023 for confirmation of the OEM authorization given by so-and-so. However, even after cancellation of the authorization on 1st August so-and-so, Pragati Engineers still participated with the same authorization till 3rd August 2023, which leads to submitting of fraudulent documents. Now, in my response before your Lordships, Malas, we have categorically said that this so-called letter, which they are saying, Malas, has never been communicated to me. Now, I'll take your Lordships to the email at page 37, Annexure D, Malas.
Excuse me, page 37.
Yes, may kindly have page 37.
Yes.
Your Lordship will kindly see, it says, Malas.
Yes.
This is, Malas, the screenshot of an email dated the 11th of August, Malas, and it is signed at, it is sent at roughly around 8 p.m. They say, Malas, dear sir, this is to inform you that our firm so-and-so has cancelled the authorization of Pragati Engineers immediately after issuing as our working terms were not matching with them. Also, Pragati Engineers was clearly informed not to place authorization of so-and-so against bid number so-and-so uploaded by Assam Rifles for installation of the product in the location of Assam Rifles in Northeast. With this, we hereby confirm that we do not authorize Pragati for the said tender. Letter enclosed for reference.
I was clearly informed not to place authorization. Also,
well, that is very interesting. Also, Pragati Engineers was clearly informed.
Yes.
Not to place the authorization of so-and-so against GM bid number so-and-so uploaded by Assam Rifles. In other words, what they're trying to say is that, Malaj, I have been informed by the OEM that I should not give this authorization in respect of this particular date. Now, the alleged letter, Malaj, is in the next page. If you'll also kindly have page 38.
Yes.
This is with reference to the OEM authorization letter number so-and-so dated so-and-so issued to you for Assam Rifles tender number so-and-so, which was emailed to you on the 31st of July 2023.
Yes.
With this letter, we would like to cancel our authorization to Pragati Engineers as we understand that our working terms may not match with your organization. You are advised to treat our authorization as cancelled for so-and-so, and this is dated Manoj the 1st of August 2023.
Okay. Yes.
Now, two aspects your lordships will see.
What do you want to show by these letters?
I'm sorry, Malaj.
What do you want to show by this letter?
Malaj, what I'm showing is the tenor of page 37 and page 38A, Malaj, do not match. Number two, Malaj, I have denied in my rejoinder affidavit filed by your lordships because till today this letter has never been communicated to me. Now,
this email.
This email is
directed
directed
to
them.
The letter is page 38.
Or 1st August. How do we verify that?
I'm sorry, Malaj.
How will the court verify that has not been delivered to you?
That's between them, my lord. As far as Assam Rifles is concerned, my lord.
Yes? Yes, Mr. Paul, carry on.
Malaj, what I was submitting is, Malaj, which is why the tender, Malaj, had a clause for clarification.
Okay.
Now, the entire case that has been put up before your lordships, Malaj, is on the issue of clarification. Now, there may be occasions, Malaj, where I have submitted a document, they wanted to verify it. The person verifying the document says that I have not issued this document or I have cancelled the document, as is the case. Then, Malaj, that particular clause automatically kicks in, and it was incumbent on Assam Rifles to then, Malaj, point out to us that, see, you have given this authorization. We contacted the OEM. The OEM is saying that it is not there, so your authorization stands cancelled.
Yes.
Well, I will take your lordships to that particular portion of the clarification, Malaj, at page 14, if your lordships can have a look.
Of the affidavit?
No, of the writ petition, Malaj. This is the tender document.
couple of fan. Page 14.
14 minutes, 1-4.
Yes. 2 days time.
Time allowed for technical clarifications during technical evaluation.
Yes.
And Malas, I had pointed out on the last occasion, of course, Malas, we had annexed the document of the, this was of the AI, but I subsequently pointed out, Malas, that the manual for procurement actually provides this, Malas, in respect of all tenders. And if your Lordship kindly have, Malas, the last page of the written petition, or on the last occasion, Malas, we had submitted the manual for procurement before your Lordships, Malas, the manual for procurement of 2022, if your Lordships kindly have it.
Yes.
7.3.5, Malas. Paragraph 7.3.5.
Yes.
During evaluation and comparison of bids, the purchaser may at its discretion ask the bidder for clarification on the bid. The request for clarification shall be given in writing by registered speed post, asking the tenderer to respond by a specified date and also mentioning therein that if the tenderer does not comply or respond by the date, his tender will be liable to be rejected. Depending on the outcome, such tenders are to be ignored or considered further. No change in prices or substance of the bid shall be sought, offered or permitted. No post-bid confirmation at the initiative of the bidder shall be entertained. The shortfall information documents should be sought only in case of historical documents which pre-existed at the time of the tender opening, which have not undergone change since then. This should be called on basis of recommendations of TC. Example, if a permanent account number registration of sales tax has been asked to be submitted and the tender has not provided them, these documents may be asked for with the target date above. So far as submission of documents is concerned, with regard to clarification criteria after submission of the tender, only related shortfall documents should be asked for and considered. For example, if the bidder has submitted a copy of an order without its completion performance certificate, the certificate can be asked for and considered. However, no new supply order should be asked so as to qualify the bidder. So what I'm humbly submitting before your Lordships is, here is a very peculiar position.
Yes.
I submit a certain document, Malas. After I submit that document, they say that they wanted to do a confirmation, Malas, which they are permitted to do. The OEM says that I have cancelled this particular document. He doesn't say, Malas, that I have never issued this document. He says that I have cancelled it. The authorization, Malas, is
dated.
The original authorization was dated the 8th of July 2023, Malas, that your Lordships would find at page 23 of my written petition, 29 of my written petition.
8-7. Yes.
Now, Malas, this 8-7 authorization admittedly was emailed to me on 31-7. That is, Malas, available in the cancellation letter at page 38 of the counter affidavit.
Yes.
The first paragraph of the Lordship, can you see? This is with reference to the OEM authorization number so-and-so issued to you for Assam Rifles, which was emailed to you on the 31st of July 2023.
Yes.
The document which was emailed to me on 31st July, Malas, stands cancelled on the 1st of August.
Okay.
Now, what I'm only submitting, and your Lordships have rightly pointed out, that it is not open for this. How would this court, Malas, come to a conclusion whether it subsists or it stands cancelled? What I'm submitting before your Lordships is, That is why, my lords, there is this stipulation in the NIT that in case of such discrepancies, my lords, it is but natural that there should have been some opportunity given to me to clarify whether it is subsisting or not subsisting. Now, for some strange reason, the authorities, my lords, decide that no, whatever is being said by the OEM is the gospel truth, and therefore we are cancelling. We are disqualifying the tender.
Okay.
Now, in this very document, my lords, the second clause that they have taken,
yes.
my lords, your lordship will find it on page 3 of the counter affidavit.
Yes.
Your lordship see, my lords, as per the instance at page 3b, my lords, OAM authorization I've already dealt with. B is test report from test lab.
Yeah.
As per instant GM, your lordships have it, my lords. May I read it?
Yes.
As per instant GM bid condition number 11, chapter 1 of the Corrigendum uploaded on 18 July 2023, the prospective bidder were required to submit test report of lightning terminal from accredited international test lab for so-and-so impulse current, as Indian test labs are capable of conducting impulse currents up to only 70 so-and-so. Mrs. Pragati participated as a reseller taking authorization from JMP LPS. However, the test report submitted by Pragati engineers was neither on the name of their OEM nor on the name of their own firm. A confirmation email was sent by the respondents to DECRA International Lab to authenticate the test report, which was submitted by the petitioner as part of the bid documents. However, the said lab has explicitly replied that the test report submitted in the bid document are in the name of Phoenix so-and-so, which is neither the OEM of the petitioner nor in the name of the petitioner. Also, the petitioner has made no mention in the said test report in the current writ petition filed by him. Neither did he reply on the issue of his representation to the disqualification. Now, I will take your lordship very quickly to my test report, fellows. Your lordship, the test report submitted by me is at page 31.
Yes.
The lordship will kindly see who is issuing the test report.
Yes, Central Power Institute.
Central Power Research Institute. I read out to your lordships, my lords, what do they say? They write some email to some DECRA International Lab.
What is the Central Power? Is accredited institute for testing?
Ballot.
The Central Power Research Institute. This is in the name of the address of customer. It is the petitioner.
Not petitioner.
I'm sorry, the OEM.
The OEM, my lord.
Yes.
But how far this report will be valid when the authorization itself is invalid, my lord? That's one aspect of the matter, my lord. My lord. I'll answer, my lord.
I am simply
The who DECRA.
My lord, what happened, my lord? As per the terms of conditions, there are 2 test certificates required because Central Power Research Institute of India has the capacity to test only up to 70 kA. 70 kA, I'll point that out. So that was the requirement was there will be 2 test certificates, one from Indian lab from CPRI up to 70 kA and one from international lab for 100 kA, my lord. Because none of the labs in India has the capacity to test for 100 kA, my lord. What they submitted, my lord, they submitted a test certificate from DECRA, my lord.
Okay, where's
my
the
lord,
test? Where's the test from DECRA?
They don't annex, my lord.
Where's that?
But I have a copy, my lord.
Okay, let him continue. Yes, please continue.
Well, the counter affidavit filed by them.
Yes.
At least, because these are the documents that are available to me. I have not come across any test report submitted by DECRA.
Yes, it is next. It is submitted, it is not been documented.
They don't annex with the writ petition, my lord. That's the whole difficulty. They suppress the facts, my lord.
It was for the Union of India to point out before your lordships that yes, this test certificate was also there and therefore we sent it to DECRA. Because my understanding was, that I pointed out to your lordships on the last occasion that the test certificate which was given by me, and at page 48 was the rejection.
Okay. Just report. This is
If you know-
yeah, page 31, right? Okay. Page, where's the
Well, if you
rejection?
want to quickly have page 48.
Yes.
This is Malad, what I get from the portal about my rejection. So, Malad, the first thing is technically disqualified due to shortfall of following documents as per terms and conditions. Invalid authorization has been submitted that we've dealt with. Blank integrity fact.
Now, Mr. Paul, you sought clarification for this, correct? You sought clarification. You sought clarification for this, for your disqualification, correct? On this page 48.
I'm sorry, page
You've sought
48.
clarification, correct?
No,
Like
no,
this-
this is Malad, what is available on the internet.
No, against this, you sought clarification from the respondents,
Against this, Malad, I filed a representation.
right?
Which they have again rejected.
Exactly. Yes. Okay.
I filed a representation that has been rejected. Now, Malad, they say invalid authorization. Now, these blank integrity pact certificate submitted. See Malad's test report neither in the name of OEM nor in the name of bidder.
Yes.
Now, I'll have to deal with this from the counter affidavit filed by them. Malad, I'll take you losses to what they have to say about this. I pointed out, Malad, that they say it is about DECRA.
Yes.
Now, your lordships would have seen, Malad, that my bid was rejected on 3 counts.
Yes.
The paragraph under reply, para 4, Malad, it just deals with 2. The third, of course, they have very conveniently forgotten. Now,
Yes.
Malad, paragraph 6 is where they talk about, they give me a 48-hour window for representation.
Para?
Para 6, Malad.
Yes.
That the defendant states that the result of the technical evaluation of which was uploaded on GM portal on 1st September 2023 within reasons for disqualification were clearly mentioned as per the given procedure of GM. A window of 48 hours was given by for the prospective bidders to represent against that disqualification. Representation received from the petitioner was very generic and it did not amply clarify the issues raised by the respondents. The defendant states since the respondent submitted the petitioner lacked credible and also shortfall false documents submitted were not historic in nature. Fresh documents resubmission should not be asked from the petitioner.
Yes.
Since also the shortfall information should be sought only in case of historical documents which pre-existed at the time of the tender opening which have not undergone change since then. These documents may be asked with a target date. Now,
Yes.
in both these two documents, my lords, the authorization as well as the test report, these are historic documents. I cannot get a fresh test certificate or a fresh authorization and give it to them. At the most, my lords, I could only clarify whether it exists or whether it did not exist. Then paragraph 8, my lords, they reiterate the cancellation. I have already pointed out this to your lordships.
Yes.
Now, paragraph 9, my lords, they write that the defendant states that all the laid down procedure were followed by the technical evaluation process by the respondents and no deviation from so-and-so guidelines has been done whatsoever. Instead, the petitioner has submitted false documents, OEM authorization from so-and-so and has uploaded blank code of integrity pack in the initial submission of documents with malified intention. As probably the petitioner was aware, the false documents are submitted. Also, the test report submitted by the petitioner is not in order, as the said certificate is neither on the name of the OEM, which otherwise has turned out to be false, nor on the name of Pragati Engineers. Then they deal with DECRA paragraph 10, that the deponent states that it is also pertinent to submit that DECRA International Lab by their email digits also has confirmed that they have never issued lab test report in the name of so-and-so or Pragati Engineers. Thus, it is evident that the petitioner by the fraudulent means participated in the bid altogether the authorization from so-and-so. An essential requirement stood cancelled on 1st August 2023. In addition, the petitioner submitted a false forged lab test report certificate. Therefore, the petitioner is resorting to tactics to abuse the process of law and to waste valuable time of this honorable court. Contentions of the petitioner are ill-founded without any merit, and therefore the petitioner is liable to be dismissed with costs.
Yes.
Now, only thing is, what now has come out, since this DECRA issue has come out, I would have to point out that where I make a mention of my test certificate, and what is the reply given by them, just bear with me for a second, just do the text. In the reply, Your Lordship, can you have a look at it? Because these documents, have been annexed by me as P2 colleague, which relevant paragraph is at paragraph 3. It's a very vague paragraph, I must concede.
In your writ petition?
In my writ petition.
What do you say?
Well, as I say that the respondent had floated a GM tender on so-and-so, bearing so-and-so, on so-and-so for procurement of lightning conductor system. And there, I annexed all my documents as P2 colleague.
Okay. Yes.
Now, the reply, Your Lordship could find at paragraph 11 at page 7.
Yes.
That with regard to the statements and averments made in paragraphs 1, 3 and 4 of the petition, the deponent has no comments to make. So assuming, that I had not annexed a certain valid document which I have, otherwise asserting my case on before Your Lordships, this reply ought to have come on this relevant paragraph.
Mr. Paul, you can't go into the weakness on the lapses to build your case. You have to build your case on your own facts. Yes. You substantiate this.
I am simply on this issue, that because I am now, what my learned friend is submitting before Your Lordship, that there were 2 test reports required. One
that has just come up now, today itself. You've not mentioned there in the affidavit also the 2 test reports.
It's mentioned.
With regard to the, are you with the 2, one is 50 and another is 100 kV something?
No, one is 70 and one is 100. That's what
okay, whatever it is.
Madam, may I point out one thing,
madam? I'm surprised, because the counter does not deal with it.
May I point out one thing, my lord? Lordship kindly turns to page 57, my lord.
Of your affidavit?
My lord.
There's a page 57.
Page 57, my lord. The last page, my lord.
Yes.
My lord, their representation was rejected by this, my lord. What it says, my lord? Refer your representation dated 2nd September 23 as per MOPG para so-and-so. During the scrutiny of documents, it was found that the authorization submitted by your firm through Mrs. JMB LPS Limited is not valid as the same has been denied by Mrs. So-and-so.
So come to 3, the test report submitted by your firm from
DECRA Lab for 100K impulse test is not in the name of your firm, neither it is in the name of, on the name of
No, where do you see an affidavit that, where categorically, where have you seen an affidavit that
two tests
reports are necessary?
This was a tender condition,
and then where do you say in your affidavit that this was not furnished by the writ petitioner, which entailed the disqualification? That could have come very clearly if that is a submission that okay, fine, you have no quarrel Central Power Research Institute. Now the other doesn't meet the standards of the 100 kV. Where is the DECRA test report? And where's the denial of DECRA? That means we have to call for the records.
They have not annexed, my lord. That's the. They're suppressing the documents, my lord. That is my case. That is our case, my lord.
The thing is that it is for you to produce the documents which are suppressed, correct? But should accompany affidavit. If you want the court to take cognizance of some documents which are very material, I mean,
they cannot deny
the document. It's not a question of not denying. It's a question, in all fairness, how do you establish a case suppressing if you also have not annexed it or produced it?
And DECRA, this is the
mail is on page 55.
Please don't access the court. Your counsel is there.
Can you look at the applicant's name, my lord? Who is this? Phoenix Contact GmbH and Company. Neither is the name of me, neither in the name of the OEM.
That is the whole case, my lord. This is the document submitted.
We understand. See, Mr. Yuban, my lord, the whole case centers around what? That is not technically qualified. And now it comes to the point that is said that a test report which is submitted by you, ostensibly done on your behalf by this DECRA lab, whatever, has been found on their verification. It was not, neither it was for you or neither was for your OEM. And so that amounts to, for you furnishing like documents which are false to validate your tender. Simple as that. And the thing is that they should have produced it and made averments there in the affidavit, which is absent.
Because your lordship will also see one very interesting thing: the rejection by the technical evaluation committee is also equally vague.
No, they mentioned DECRA there, but in the affidavit they have not given any supporting documents.
No. My lord, in the cancellation it is not mentioned. That takes a lordship.
It's mentioned DECRA. I see page 58, 57.
57.
Yes.
Page 57 of, my lord, this is in the representation.
Exactly.
This is post my lord, disqualification. This is post disqualification. I am at the stage of pre disqualification. If your lordship kindly look at my.
Dr. Murthy, I put the records. We'll take it up tomorrow. Let the court look at the records within the process.
My lord, if I may submit, my lord, this is a case of suppression of documents by them, my lord.
Fine, but then have you made out a case that there has been suppression at all? You're not in made any averment here. That they've suppressed it, that they submitted a report of DECRA. It's only after a clarification. The clarification says DECRA comes a picture.
Because your lordship may kindly look at my rejection at page 48.
My lord, my averments, my lord, at para 4, my lord.
At page 48, your lordship will see test report neither in the name of OEM nor in the name of bidder. That's all. It doesn't say, my lord, which test report. If there were two test reports,
my lord, para 4 of my affidavit, my lord. There's a table, my lord.
Yes, I think B.
Mrs. B.
Yes.
As per instant GM bid condition number 11, chapter 1 of the corrigendum uploaded on 18 July, the prospective bidder is required to submit test report of lightning terminal from accredited international test lab for 100K of impulse current, as Indian test labs are capable of conducting impulse current up to 70 Ks only. Then, my lord, may I just continue?
Anything? You're through your submissions, Mr. Paul? Let Mr. Muska reply, yes.
No, what I am submitting before your lordship, irrespective of the fulcrum of my submissions before your lordship is this.
Yes.
Assuming,
yes.
Only for the purposes of argument that these documents were not there or there was some falsification of documents, which now they are trying to make out that there was some falsification of documents. All the more reason, my lord, there should have been some clarification.
Yes, okay.
That these documents we have submitted, I would have to be faced with both those two letters saying that, my lord, both of them have said A, your authorization is cancelled. B, DECRA says that it is not even your test report. And I would have to be answerable, my lord, because these are the very two historic documents they are talking about. At the time of submission of these bids, these two documents were being submitted by me.
Okay.
If subsequently, my lord, the technical committee is to come to a finding that these are invalid documents or these are forged documents or false documents, whatever it is.
So your submission is that what's it called? This what is the
OEM authorization?
No. No, 1 second.
Test report, my lord.
No, wait.
CPRA.
Where's that? Where's that directive? What's it called? Oh, this one, yes. Oh, yes. That means your submissions that the manual for procurement of goods as per clause 7 has not been complied with. That is submission, correct? 7.3.5. That is that not clarified as per the requirement of 7.3.5. Is that your submission?
Correct.
Yes, okay. That means 7.3.5 not complied with. Okay.
Well, what I'm saying is that 7.3.5
Yes.
gateway.
Yes.
Well, page 14, time allowed for technical clarification.
Right. That's on 7.5. That 48 years, two days not given. Okay.
Lordship.
Right. And next point.
What ideally should have happened is, my lords, if these documents had not been given or they were found to be false, forged, whatever.
Within the 2 days window, they should have clarified it, and in the reply, they should have yes, indicated that. Yes.
In an ideal situation, if your lordship grants me this indulgence, in an ideal situation, I submit an authorization by firm X. It turns out firm X says that no, that authorization has been cancelled. So if that authorization has been cancelled, my lords, I would have to be met with that cancellation and saying that, oh, you submitted this, but this is invalid, so we're rejecting you. And you show good reason as to why we should not reject.
Right. Next point.
Similar with DECRA, my lords, assuming only for the purposes of argument without admitting anything, my lords, that if that test report was indeed not in my company's name or my OEM's name, and there was some kind of an email communication that they are privileged with, where DECRA says that it is an invalid test report,
right,
I would have to be met with that test report.
Okay, yes, that's Dr. Mishra.
If after that opportunity of 2 days, 48 hours is given to me, then I cannot satisfy them, I would have no case before your lordships today.
Right.
That's the advantage of his being on VC, my lord. He can prevail over others, my lord.
No, yes. Now let Dr. Moskar reply.
I am not trying to prevail, my lords. I am only submitting. My learned friend is, I'm sure, going to have an article of his own.
Yes. Yes, Dr. Moskar.
The only other thing that I'm submitting is, my lords, that in public procurement, fairness of state action is a central principle, my lords, your lordships are aware. And, my lords, I would also say that justice should not only be done, it should appear to have been done. Assuming, my lords, that these documents were not there, at least the process followed by them, that, my lords, does not smack of confidence.
Yes.
And your lordships would have noted what is written in paragraph 2.
We have noted.
I have pointed out before your lordships, they say that because the writ petition was pending before your lordships, therefore, my lords, the technical evaluation committee decided to proceed in these lines.
Well, my lord, just for
no, you can't have zero submission.
No, my lord, assisting only, my lord, assisting only, my lord, because of this. Only one date that I just wanted to, which my lord, my senior has just left, just to add that one only. That, my lord, in the page 3, paragraph 4 of the counter affidavit, my lord. When did the when did we come to know of, when did they forward it actually to us? Bringing on report, yes, cancel it. That's on the 1st September 2023, my lord. And may I just be allowed to read just
I've seen that, yes.
Yes, my lord.
Also, along the email, JMP has attached the copy to the official letter of authorization, which is forwarded to dated 1st September 23.
My lord, that is all.
No. Enough.
My lord,
yes.
My lord, what I gather, my lord, from the submissions of the petitioner, my lord, that they are only on 2 issues, my lord. Number one, that they are not aware that their OEM authorization has been cancelled, my lord.
Yes.
Now, my lord, our first submission in that regard is, my lord, this is between their OEM and them, my lord. If they are aggrieved by the actions of the OEM, my lord, they should file a damage suit, my lord.
Yes.
That is not for Assam Rifle to enter into that dispute, my lord. That's our first submission, my lord. Second submission, my lord, clause 21 of our NIT, my lord, clearly says, at page 32, my lord,
of the petition
of my counter affidavit.
Page 32.
Page 32.
Yes.
Clause 29 towards the bottom, my lord.
Clause 21.
29. Page 32.
Yes.
Number 1, OEM authorization. In case of reseller, the bidder has to submit bid-specific OEM authorization certificate with details such as name, designation, and address, email ID, phone number, bid number. In no case general OEM authorization will be accepted and bid is liable to be rejected. The OEM authorization can be verified if necessary.
Okay.
So, my lord, we have clear authority to verify the OEM, my lord.
Yes.
So, when we send a email to their OEM, my lord, your lordship will find that at page 37, my lord.
Yes.
But the mail at the bottom, my lord, outside the box, your lordship will see. This is sent by mail sent by Assam Rifles to the OEM, my lord. It is requested to please confirm that your firm JB so and so has offered authorization to Mrs. for supply and installation of EEC-based lightning conductor against GEM bid number so and so dated so and so uploaded by Assam Rifles for installation of the product in the location of Assam Rifle in Northeast. An early response is requested as the bid is under technical evaluation process. This is a routine confirmation required by the buyer side to check the authenticity of the seller participated in the said bid. This mail was sent on 11th August at 9:32 morning, my lord.
Okay.
We get a reply, my lord, by evening on the same date at around 8 p.m., my lord. The reply is, this is to inform you that our firm, Mrs. So-and-so, has cancelled the authorization of Mrs. Pragati Engineers immediately after issuing, as our working terms were not matching with them. Also, Mrs. So-and-so was clearly informed not to place authorization of Mrs. So-and-so against GEM bid number so-and-so dated so-and-so uploaded by Assam Rifle for initiation of the installation of the product in the location of the Assam Rifles in Northeast. With this, we hereby confirm that we do not authorize Mrs. So-and-so, so-and-so, so-and-so. So, my lord, this is one aspect of the matter, my lord. Once we get a confirmation from the OEM that they are not the reseller now of that particular OEM, my lord, can we accept the tender, my lord? Can you technically pass the tender, my lord? That is the question. Secondly, my lord, now we go, this has a direct relation with the test certificate also, my lord.
Yes.
But by submission, if in the given circumstance, if we accept this tender, my lord, there will be other bidders coming to court, my lord. Now, JMB is their OEM, my lord. They submit that CPRI certificate of JMB, my lord. 70K. First question is whether that can be accepted, my lord, when they are not the reseller of JVM, my lord.
GMV or JVM?
JMB, sorry.
Okay.
In my submission, my lord, once they are not the authorized resellers, my lord, they cannot even use that certificate, my lord. That is the first aspect of the matter, my lord. Second aspect, and more importantly, my lord, clause 11, there are two clauses, my lord. Clause 10 requires from CPRI, my lord, and clause 11 requires from any international laboratory for 100K, my lord.
Where is that clause?
My lord, we have mentioned in para 4 of my counter affidavit about that matter.
B.
B, my lord.
GM Bid Condition 11, Chapter 1, Corrigendum, uploaded on 18 July 21. Corrigendum.
But the complete corrigendum has not been annexed, but I have a copy, my lord, of the Chapter 1, my lord.
Yes.
Yes. Has the contract been awarded? Not yet.
Sorry, sir.
Contract awarded?
It's over.
It's been awarded.
Yes.
My lord, this was the original bid, my lord.
Para 10.
Para 10 requires 5 positive and 5 negative pulses of 70 kA impulse current shall be provided by the vendor. CPRI test certificate, central power resource, my lord. And second requirement is the vendor shall provide May2 certificate. Now, in the earlier round of
Turkish,
my lord, so this has been amended, my lord. I'll point that out, my lord. The vendor shall provide May2 test certificate in lightning terminal in accordance with test procedure number so and so for minimum 100 kA.
Okay.
My lord, the corrigendum your lordship will find here. 35. 35. Page 36, my lord.
Of your affidavit.
My affidavit.
Okay. Okay. Contempt.
Now the requirement has been changed, my lord.
Right.
Because they had a lot of grievance with
Understood,
Metu.
understood. Because they had come first time for
only
selling
that,
the tender conditions. Right.
It says, my lord, at page 36.
Right. Para 11.
On the right hand side, my lord.
Yes, para
the vendor,
okay.
my
Yes.
lord, from any international lab, my lord, of 100 kV.
Okay.
To meet this, my lord, I provided a copy. They annex a certificate of DECRA Laboratory International, my lord, which is issued in the name of Phoenix Company, my lord. That is neither in the name of JMB nor in the name of this Pragati Engineers, my lord.
Okay.
My lord, the mail from DECRA is at page 55, my lord. My lord, it says, my lord, DECRA certification BV hereby confirms that the report is authentic. Then on the next page, your lordship will see. Then we sought a clarification that whom the certificate has been issued. They reply, my lord, at page 56. We have issued this report to our client Phoenix Contact GmbH and Company KG as mentioned in the first page.
Where is this Phoenix Contact GmbH? Germany?
It's a German company, my lord.
GmbH is German, yes. Right. Anything? Yes.
My lord, this is the second aspect, my lord. The third aspect, my lord, para 5.3.7, my lord. That
7.3.5.
7.3.5, my lord. That only talks about historical documents and examples have been given, my lord. PAN card, VAT registration.
Okay.
My lord, so at the most we can stretch this to a similar kind of document. We cannot bring in within the ambit of this, my lord, a document which is altogether something, a totally different document, my lord. Moreover, my lord, 48 hours opportunity was given to them. My lord, and most importantly, my lord, is there any averment, my lord, in the writ petition, my lord, that till today, my lord, till on the date of hearing, they have a 100 KA certificate from anywhere, my lord, number one, and number two, they have any OEM authorization from any manufacturer.
Okay.
So, my lord, they are not entitled to any relief, my lord, because they have not come up even today before this honorable court with those two very essential documents, my lord.
Why didn't you? And then why didn't you regarding that DECRA? Any doesn't matter now. Yes.
Because my lord will notice that both the certificates are invalid, my lord. Once JMB authorization goes, even the JMB certificate of CPRI is invalid for them, as far as they are concerned, my lord.
Okay. Anything else?
Yes,
we'll pass orders then.
Right.
Yes.
A quick response on just one thing.
Yes.
What my learned friend was reading at page 35.
Yes.
Let's take a lordship's to page 35. My lord, the corrigendum for GM bit number so-and-so dated 27 June 2023.
Yes.
The second column rather, my lord, your lordship will kindly see.
Yes. Revised specifications.
Conditions.
Yes.
And the next column is, my lords, revised specifications conditions. So
yes.
Column 2 has been substituted by column 3. Now, if we read column 2, my lords, down below at page 36, your lordships may kindly have a look. The existing, the original conditions is in column 2, my lords. The vendor shall provide Me Too test certificate of lightning terminal in accordance with the test procedure.
Yes.
Number 2, Appendix C for minimum 100 kV impulse current wave type test report.
Yes.
Now that was substituted in the corrigendum issue. Now how does it read, my lords? That the vendor shall provide testing certificate of lightning terminal from any accredited Indian international lab in accordance with the test procedure number so-and-so for minimum so-and-so impulse current wave and test cycle. So it is other way around, it is not there are these two documents, what originally was, and if I remember correctly, that was something that we had pointed out, that the original test report scale was of France. So subsequently, that was changed in the corrigendum, and then that reach of any Indian or international lab.
Okay.
So unless a case has been made out before your lordship that there was a requirement for two tests, in my humble submission, at least this does not establish that.
Okay. Yes.
That's all.
We'll pass orders.
My lord. I've been instructed that maximum capacity of CPRI or any Indian lab is 70K only.
You already submitted that, yes.
Second call, item number 2. Second call, item number 2.
What has happened, Dr. Mozika?
Here the new policy has been issued, my lord. Though it may not be to their full liking, my lord, but policy has been issued.
Our liking or not, my lord. It's a policy decision. What this honorable court will only
in contempt now, whether we can go
yes, my lord. Why I will say, lordship will kindly have the policy for a moment. I'll just point out two things in the contempt and the earlier orders of this court. Whether this policy is in contempt. That is what lordship will say.
Now we'll have to file a fresh contempt.
My lord.
You will file a fresh contempt
No,
application.
when they do it during the contempt proceedings, saying
Exactly,
that we are bringing in
whatever
something.
it is, this will not mean that it will be disposed of now.
My lord. Yes, that will be another that will be another issue. But
that is on a different footing now.
My lord,
This the new development is be a different footing.
My lord. Lordship will kindly have before we go to the policy, my lord, just if lordship would kindly have page 17 of the contempt petition, which speaks of the old policy. The one they are now trying to replace. It starts at page. It will start at page, my lord, 15, and I would take lordships to page 20. This was the policy of 2021.
Yes.
Page 20, clause 12. Keeping in view the constant deficiency of specialists in the medical cadre of CAPF, it has been decided that GDMOs with PG qualification will be treated at par with specialists for the purpose of their posting. GDMO with PG qualification will be treated at par with specialists. Based on this policy, this very statement, this honorable court had passed an order in the earlier round of writ petition, orders of which now contempt is being arranged, at page 27. Starts at page 26, para 4. Lordship would like to have para 4.
Yes.
Dr. So-and-so learned ASG, assisted by so-and-so learned counsel for the respondent, submits that the issue has been taken into consideration in the policy decision itself, wherein it has been decided that GDMOs with PG qualifications will be treated at par with the specialist for the purpose of their posting to ensure maximum utilization of their specialization. He further submits that it must be kept in mind that the GDMOs attain specialization while in service at the expense of state, whereas the specialists who came into service were already pre-qualified as specialists. Be that as it may, in view of the compliance of the respondents to the order of this court, when the matter has been considered and policy guidelines issued, writ petition is disposed of. Therefore, the issue in the writ petition was the GDMO with specialist qualification be given equivalence with specialists for in the matter of promotion. They came out with a policy. This honorable court was pleased to close the writ petition because the matter was then settled. Now the new policy during the contempt petition, which they try to bring on record, saying that there is no contempt. Lordships kindly have paragraph 3 at page 2. GDMOs with PG qualification are basically recruited as per provisions in the recruitment rules, and the primary duty is to perform the duties of GDMO and hence cannot be considered at par with direct entry specialist medical officers. I'll pause here for a moment, my lord. A writ petition is filed claiming equivalence. Policy is done. This court is told that we have given the equivalence, close the writ petition. Now, a new policy introduced, because when we come up with a case that, look, they are not giving us the equivalence, they are not implementing the policy. They say, we are now reconsidering the policy. To close the contempt, now they come up with a policy saying, we are not giving you the equivalence, go for a fresh cause of action. Each time we approach the court, since 2000, Lordship will find this order, the earlier writ petition was of 2018. They have it closed in 2021 saying we are granting the relief. Please close the writ petition. We don't want the litigation to continue. They grant us the relief, a statement is made, a policy is made, the writ petition is closed only on that count. 2 years down the line, in a contempt, they say, we are retracting the policy,
now
we are
what
going
do we
back
do
to
now
square
with
one.
this new policy? You'll have to challenge it.
Well, this policy has come up day before yesterday. But when a writ petition is closed on a statement.
You see, you can make all those statements, but we have to, it has to come on record.
My lord, this has come on record to show that we are going back on our words.
You have, the court pram facie is clear. So that you know what to do. The court not in an advisory capacity.
But then, even otherwise, my lord, allowing them to have a contempt closed by retracting from what?
No. We won't close this contempt.
My lord.
You know, I could not advise you what you have to do. I just say that
my
DSGI.
My lord, my after this, my lord, a fresh cause of action for a writ petition arise.
Whatever, see, we're not going to advise. Yes, Dr. N. Mozika at DSGI has today produced what is this called?
It's just called policy regarding posting transfer of
specialist.
Posting policy.
Policy regarding posting and transfer of specialist medical officers and general duty medical officers (bracket GDMOs) with postgraduate (bracket PG) qualifications in CAPFs, NSG and AR-RAG dated. What's the date?
This is 18th of September.
18th September 2023. Stop. It is submitted that by the new policy, the issue regarding forget it. Just write that copy of the same is made over to the counsel for the petitioner, who seeks time to take instructions and to take appropriate application. Yes, this is matter after
a week.
You file it when there will be after 1 week. Yes. Very strange, Dr. Mozika, because if the entire list of the earlier case was at parity, and then after giving them a parity in terms of posting, so they'll use maximum usage of the GDMBOs. So then again, now you revert back to square one by bringing the disparity again.
My lord, what happened actually, my lord? Assam Rifles and ITBP, because of their peculiarity, my lord, they are either in Himalayan region or northeastern region.
No one wants to come here.
My lord, they are facing the maximum difficulty in posting the GDMOs, my lord. Because Assam Rifle only has one composite hospital in Dimapur, my lord. The problem is that we have other hospitals in many other places, but
no one wants to go there.
No one wants to go there.
Because if they have parity, they have anyway. Yes.
Item number 9.
We will see what course it takes. Yes. Second point. Yes, Mr. P.T. Sangma.
Yes, Lordship. I am aware because this copy I have given to my friend also. Because, can be disposed within some time frame, maybe given to the petition to pay.
They already written there and clear answer.
No, yeah, that's saying that they will comply all this whatever phrase annexed to us, but the annexed to is there.
Today, where's Mr. D? He's disappeared.
I was instructed to appear.
Yes. You are?
M. Hajong.
M. Hajong, yes. M. Hajong, Vice Mr. S. D. learned counsel for the respondents has produced an office memorandum dated 4th September 2023, whereby the Executive Committee of the Garrison Compensation Council has approved the formula for calculation of gratuity to the employees, to the employees as per notification dated 7th October 1988, Rule 2 within bracket 8 of the Contributory Provident within bracket Council Services close bracket Fund Rules 1963 with immediate effect. Next paragraph. Mr. P.T. Sangma submits that with the issuance of this memorandum, the grievance of the petitioner has been redressed. Accordingly, the writ petition stands closed and disposed of.
Lordship, just to pay some time frame, just
with immediate effect, they're implementing it.
Immediate effect.
And they have no money. They're on strike. It's on his paper also.
Hearing?
So
Supplementary list?
Good luck.
Lordship, because 2000 IOS retired on 2000, Lordship.
File a fresh petition.
No, actually, just give me some time because they may just delay.
You're very fast. I think you can go and draft out and come back.
No, Lordship, this is not the case here, Lordship.
Yes.
I humbly pray by that. Just
hearing.
No, Mr. Pisangma, enough. You have come with a different prayer. You can extend your prayer.
What's your last, Lordship?
Your Lordship, I pray that this matter may come up after some time. Mr. KP is on legs, Your Lordship.
Yes, follow other matters.
Obliged, Your Lordship.
Main list, item 23. Main list, item 23.
My lord, 23, 24, my lord. Those contempt matters, my lord. Which the some Russians are basically saying that we are pulling a dead horse, my lord. But then we are actually trying to free a horse, my lord, which has been bound down by them, my lord.
May it please your Lordship, I'd like to have your Lordship's indulgence for these two matters, your Lordship. It can be listed any other day, your Lordship. Since the brief, we've not brought the brief with us today, your Lordship.
Yes.
Well, I was making a similar prayer also because Lordships have indicated to your Lordship's mind primacy, and I had prayed that some time be given to me to try and satisfy your Lordships that this would be maintainable.
After 1 week, on the prayer of the parties for the party, on the prayer of the councils for the parties.
25.
Lordship, on earlier occasion, I prayed for time for the instruction pertaining to their proposals of settlement. But my instruction is that she is not agreed to accept 50,000 rupees.
Then we'll dismiss your case. Yes. You can't understand. Yes, you can't make him understand.
My lord, I have been actually because of this case that's been pending. So we are saying that we'll give you 50,000. Even what my ex-husband is maintaining was not that much under the maintenance order.
See, because it's this is a matter concerning.
For me also, this is a legal aid. We are very poor.
Yes. You're doing legal aid? No, she was legal aid before.
Yes, sir.
Now she's got the money to pay lawyer.
No, I'm doing pro bono.
You're doing pro bono. So pro bono, at least take something.
No, Your Lordship. She's saying that she's not willing.
What's she saying? She wants everything.
No.
Have you told her that she'll not? The matter was heard that the courts indicated that you'll not get anything, and he's offering 50,000.
I have explained, Lordship.
That the case be dismissed. You told her the case be dismissed.
Lordship, she is saying that I was married with him.
See,
and
sometimes a client will not know about the law. Correct.
Lordship.
It's the duty of the counsel. Now you can't, sometimes that what the client tells you doesn't mean that you have to, just repeat that before the court. You have to balance the law and the facts. Correct. So you have to make your client understand that maybe the facts are good, but then you don't have any substance to, to support your case. And going by materials here and then the orders of the lower court, that means no relief can be forthcoming to you. We'll give you one more chance. Can you convince her? At least let her take something, otherwise she'll get nothing. Mr. Ubed has kindly said, okay, we'll give 50,000. You take it, even though you're not entitled.
I'll try.
You try, otherwise.
All right.
Yes, Mr. B, please, he may allow some more time to try to convince his client. Oh no, we say adjourn. Mr. B, please, the matter be adjourned for 2 weeks to enable him to obtain further instructions.
All right.
Otherwise, the offer will be withdrawn. Then the matter.
26.
Yes.
And in this case, the government have filed 3 affidavits. The private respondent filed 2 affidavits. And
2 affidavits means 1 and 1 additional affidavit.
In every situations, they file an affidavit to clarify.
Yes.
So
yeah, my lord, only they are asking for salary, nothing else.
No, but salary, here the case is very simple case.
Whether entitled or not, that thing you have to decide.
No, this is a salary. Here the salary was withheld by the managing committee. Then we file a petitions before this court to release the salary of the petitioner with effect from May 2021 till date, till the filing of the petitions. Means prior to that I was getting a salary, but suddenly because of change of the managing committee, they have stopped.
So, yes, sorry.
Prior to that I was getting a salary. I am a sanctioned teacher. Now, before filing this instant case,
are you still working?
Still I am there because I am still sanctioned.
Being there is different. Are you working?
In this case, what happened? After the managing committee change, new managing committee was constituted last year, October. Though we are going to school, but they are not allowing me to enter the school or to sign the attendance register. But the question is that...
Who is teaching in your place? Mr. Pandit? You are teaching in his place?
Yes. Let's see, there are other teachers also, and 3 SSS teachers are there. They are getting salary directly from the government in their account.
Sanction teachers.
SSS teacher. And the petitioner, your lordship, she is not attending the school since 2019.
No.
2019 she is not. We have issued SOCOS also, and she has not replied to that.
You are for a managing committee?
Yes, your lordship.
Managing committee, lordship, they are saying you are the ordinary teachers appointed by the managing committee. But our contention is that...
Why you have attended duties from 2019?
No, we are attending. They stopped me entering the school only after the change of the managing committee.
Just let him finish his submission. Now you say that where is the appointment order?
Yes, here. This annexure 4, page 14.
Annexure
4, page 14.
Page 14.
Page 14.
Very good.
In continuation of so and so, the teacher was appointed with the terms and conditions. So I am a language teacher. I'm the language teacher.
No, your name is Afroza Khatun.
Afroza Khatun, yes.
Okay.
Language teacher. Let's say prior to that, it is a second round litigations. Before that, there was a litigations. In that case also, they have stopped the salary. And page 15. Page 15 is the order passed by the Honorable High Court.
Page 15.
Page 15. Annexure 5.
That's page. Okay.
Admitted producer as appeared from the prospective submission of the Learned Counsel for the parties that petitioner is working as a teacher in Popomari Girls Upgraded UP School, West Garo Hills. The salary in his favor has been released and paid up to March 2018. The grievance of the petitioner is that her salary with effect from 1/4/2018 till date has not been released. As such, is facing serious financial hardship. According to GA, the respondent released the salary up to August 2018, which is to be paid to the petitioner by the managing committee. In support thereof, he has produced a Xerox copies of the sanction order, same to be taken on record. It is further submissions, the learned GA, that the release of salary beyond August 2018 is just subject to availability of fund, but assured that as soon as the fund are released by the government of India, sanction order will be issued for payment of the salary for a period of September 2018 onward. The managing committee for its payment to the teachers, which includes the petitioners. In view of the stated positions, nothing survived for determination in this petition. Suffice to say, the managing committee of the school shall ensure the payment of salary to the petitioners 1/4/2018 till ending August 2018 within 10 days. Thereafter, release of funds by the central government and sanction thereof by the respondent to pay the salary to the petitioner regularly thereafter. So they have not paid the salary in spite of the order of the court. Then I file a petition for contempt. I file an application to the contempt proceeding. This is annexures 7 and page 18.
So you threaten them and they filed with contempt and they coughed up the salary.
No, contempt because they have not complied. Otherwise, they could have filed an appeal against this order. Nobody filed an appeal. Then they appeared before the court. Learned counsel for the respondent, affidavit of opposition shall be filed within a week. Learned counsel submitted that by virtue of the order so and so, this court disposing the petitions, directing the managing committee to make a payment of salary to the petitioner with effect so and so. Adjourn. It is directed.
Okay, yes. Then what
that is
so
the order.
You appeal up to August.
Then after that there was a final order passed. The contempt was disposed of.
Okay, contempt was discharged.
Contempt was discharged. Page 19. The final order was passed.
The appointment order is annexure 1.
Annexure 1.
Yeah, this one is.
So this is an appointment order.
Okay, approval is this annexure 2.
Annexure 2.
It's 16.5 on 16.5. This is not 16.5. As per resolution dated, which is that 16.5/2013 resolution.
16 resolution. The managing committee of the school appointed so and so as a.
No. This appointment order is dated 2010, and the approval is of some resolution dated 16.5/2013.
Appointed when the school was
provisionally approved.
Provisionally approved.
You were not approved formally. Finally.
Formally, yes.
Then what's annexure 3?
Annexure 3 is a managing committee. In the managing committee, I was the teacher representative.
Okay.
Just to show that I was a teacher
then,
representative. Annexure 4 is the order. He said, in continuation of this office order so and so.
What is the status quo?
In view of the status quo report,
or the
status quo report of genuine
resolution is 16.5
submitted. In pursuance of the approval, the following teachers, as per detail, is hereby considered as a teacher appointed under SSA with the term and condition stated in the order so and so. So here I am not alone. The 3 teachers are appointed.
No, fine.
3 teachers are appointed.
Right. Because there was some question about genuineness of the resolution dated 16/5/2013. Correct?
Yes.
Okay.
This is the order.
These are all documents you have with you.
Yes.
What do you see in the affidavit?
So now in the affidavit, Lordship, at the very outset, they have taken a plea that this approval order given by the government, this annexure 4, is a forged order, is a forgery. He said it was not issued from the office.
Where is that? In the affidavit of the first affidavit of the states?
Yes, affidavit of the private respondents, and thereafter the court has
Zarika, where we said that in the affidavit?
Forged.
How many affidavits you filed?
He filed 3 affidavits. In the 3rd affidavit, he took a U-turn because the court was asking, if it is a forgery, then what action you have taken? That's what they filed an affidavit. You intimate the court what action taken. The managing committee said I cannot take action. It is the government to take action. The government is saying I cannot take action. It is the managing committee to take action. So both of the parties did not take any actions to say. Thereafter, I filed my rejoinder. I applied for the RTI whether I am a sanctioned teacher or not. In the RTI, the departments from the Tura, they have given a letter is saying yes. As per the report, RTI report given to me, I am the sanctioned teacher. After getting the RTI from the department, then they have changed their stand. Then they started saying that I am not attending the court, I am not attending the school, I am not going to the school, I am not interested in the school. They have to change their stand. But my question is, their lordship, I am the sanctioned teacher, and even if if my appointment is cancelled, it is not. There is no such approval order. And one thing they have concealed, I do not know. Till today they have not disclosed. If I am not the sanctioned teacher, others are not sanctioned teacher. Who are those sanctioned teachers? Not disclosed by the government, not disclosed by the private respondents. Rather, private respondent, I have in annex 1 letters in my rejoinder, he was a 4th teacher, and that also was cancelled.
The rejoinder is the last affidavit.
Last affidavit.
1210.
1210.
Where's RTI reply, you say?
RTI reply.
This one at Annex E 95.
Annex E, yes. Annex E.
Where does it say? There's a chart.
Charge. Fund is herewith information sought by the RTI. In this case, they have given the chart. My name is.
Your name is Afruza Khatun.
Afruza Khatun.
Then you're shown as health and physical education.
No. In the reply to the query.
Oh yes.
Afruza Khatun is a language teacher. And with regard to the letter, they said the letter was issued from the office only.
You're teaching health and physical education. And art education, I don't understand. Yes. What do you say to this, Mr. Pandit?
Your Lordship, there were some
Now,
anomalies.
who are the sanctioned teacher? You say that Afruza is not. Then who's appearing for private respondents? What's the private respondent's name from this list? Come to this rejoinder affidavit, page 20.
Page 20. As per Your Lordship, there are 3 teachers, sanctioned teacher: Afzal Haq, Hasina Mumtaz, and Tafsin Ahmed.
Tafsin Ahmed.
Yes, Your Lordship.
Okay.
These are the 3 teachers.
Now, Tafsin is non-sanctioned.
Yes.
Now, Afzal Haq sanctioned.
Yes, Your Lordship.
And Hasina Mumtaz sanctioned.
Yes.
And the petitioner sanctioned.
Tafisuddin Ahmed, Your Lordship.
Is non-sanctioned given by the government?
Yes, but Your Lordship, the salary, Your Lordship, they are getting directly in their account.
Why then when there's been some manipulation then by a managing committee with regard to this Tawfiquddin. Is he represented here?
Yes, no, he is not party.
Why?
Yeah, he's a party managing committee.
He is the representing managing committee, Your Lordship. He is signing as a ex-officer, but personally.
Who is Tawfiquddin? He is the secretary managing committee.
Headmaster of the school.
No, that means he appointed himself to a sanctioned post.
No, Your Lordship. He was appointed by the managing committee.
Where's his appointment order?
He is not party, Your Lordship. In this.
You produce it.
Yes. Yes, sir.
Just write down. In the course of hearing, an RTI reply has been referred to by the Council petitioner dated 2/9/2022. Stop. In the said RTI reply, the petitioner, along with one Afzal Haq and Afzal AFZEL HOKUE and one Hachina. H is Hasina or Hachina?
Should be Hasina.
So we'll give as is given here. And one Hachina Momataz, HACHINA. Then after Momo, MOMO, TAZ are shown as the 3 sanctioned teachers of the school. Stop. stop. Next part. Mr. S. Pandit, appearing for the Management Committee, however, submits that it is one Tofish Uddin. TUFIS. What the name is like?
Tofish. TOFISH.
SH Uddin.
UDDIN.
Ahmed, who is a sanctioned teacher. Stop. He also submits that the said Tofish Uddin Ahmed is the ex officio. Is functioning as secretary of the present management committee.
Yes.
Correct. Yes. Mr. Pandit to produce appointment orders of the set of on the next date. Now we'll get to the bottom of it.
Yes.
If you somehow inserted yourself laterally and kicked out the petitioner.
Let's say appointment and approval order both required.
Appointment and approval, yes. Yes, after
3 weeks, Your Lordship.
3 weeks?
Yes, sir, because
Why is
from
it
Garo
fresh in the mind for court, huh?
from Garo Hills.
You have to go yourself to collect it?
No, Your Lordship.
Yes, after 3 weeks. Call finish it, otherwise, yes. He has a point.
Yes, Your Lordship, but
If there's a document by Mr. Hazarika's respondents that the precious sanction teacher, correct? Yeah, we are taking the stand now.
Now,
Orders will follow also if the allegation is made that an order is fraudulent. If the order was, you see, it has been fabricated.
Yes.
That also will pass orders on that.
Another question is that the same date, same number, another order also is
We'll
there.
get to the bottom of it. Yes.
27.
Because we are only for that salary. Now he is not in the school, so he is not entitled to salary as per our inquiry report. Finish. This much only.
So let him produce.
If non-sanctioned, we are not concerned.
Yes.
This matter, may they kindly have it any date but next week.
Anything remains here?
The legal issue subsists.
You're just dragging this matter unnecessarily, Mr. Paul.
The legal issue subsists because there has not been any quietus in view of the affidavits filed. The legal issue will remain.
Let's give him one opportunity. Let him come in person. This is matter for 1 week. Yes. It's understood. The next date, no further adjournments will be sought for.
Was it like
28.
Well, in this case, the friend from other side seeking for some accommodation.
Accommodation, what happened? Too many matters in one day.
Yes, senior told me. A week.
The senior has informed.
Some problems. On the request of MSS from Tha by the almost.
1 week.
This matter of 1 week is.
Deeply please.
29.
Okay. Only. I'll just come back in 2 minutes. Yes.
Please, Your Lordship. Your Lordship, this matter pertains to claim of family pension by the petitioner, who is the legally wedded wife of one late Om Kumar Lama, who during his lifetime was working in the office of the respondents as a sub-inspector. Your Lordship, during his lifetime, late Om Kumar Lama was married to one Suku Lama who predeceased him.
Sorry. I'm sorry. And what are you saying?
During his lifetime,
The petitioner is whom?
a legally wedded wife, Your Lordship.
She is the one Om Kumar Lama.
Yes, he was working in the office of the respondents as a
Which
sub-inspector.
respondent? You are paying for them?
Yes, Your Honor.
Wife
I'm
respondent.
for the first wife, Your Honor.
Which department is he working?
Directorate of Anti-Infiltration.
Okay, yes. Yes, then?
Now, Your Lordship, during his lifetime, he was married to the mother of the respondent herein, who
Married to
predeceased
the-
him. Suku Lama, who is the mother of the private respondent.
No, just easy. Now the petitioner is the legally wedded wife of?
Yes, of late Om Kumar Lama,
Okay, Om Kumar Lama. Who?
who was working in the office of
Okay,
the
fine.
respondents.
Yes.
Now, during his lifetime, he was married to one Srimati Suku Lama.
Before
who
marrying
predeceased him,
you?
Yes, and she
Okay.
predeceased him.
Okay, then?
Thereafter, in the year 2012, he married the petitioner.
Okay,
Now, in the year 2014, a child was born to them.
okay.
Thereafter, in the year 2019, he was hospitalized at Bethany Hospital and he succumbed to his illness in the year 2019.
Yes.
On his death, I approached the office of the respondents for claim of family pension.
Yes.
Now, the office of the respondents stated that there are two claimants and he has nominated his first wife and his two children from the first wife.
First wife is deceased.
Yes, Your
Yes.
Lordship. Thereafter, Your Lordship, I made a representation stating that I am the legally wedded wife. As such, I am also entitled for claim of family pension. Thereafter, the office of the respondents had sought for the legal opinion of the learned Advocate General, since there were two claimants. Now, the learned Advocate General has opined that both of us are entitled for claim of pension at 50% share. Thereafter, Your Lordship, they asked us to produce a succession certificate.
Yeah.
Now, Your Lordship, for claim of family pension, succession certificate is not required because it's either a debt or a security. As such, Your Lordship, another letter was sent to them clarifying them the same. Thereafter,
So why don't you agree?
Your Lordship, the marriage is not legally valid, Your Lordship.
The child's entitled, even the marriage is legally entitled.
Everything has been, document has been fabricated, Your Lordship, and placed before this
The birth
court also.
certificate is fabricated.
Everything is fabricated, I will prove, Your Lordship. I have filed my rejoinder in this regard.
Your Lordship, the office of the respondents are
Yes.
saying that both of us are eligible. I am the legally wedded wife.
Where's your marriage certificate? Oh,
Your Lordship, page 20 of the petition.
this is from where? Where's this place from?
She was
From
married
Nepal.
in Nepal, Your Lordship.
Chitwan, yes. Yes. And the birth certificate of the child?
Birth certificate is at page 22.
This is a death certificate 21. It was with
22,
you.
22, Your Lordship.
22. Okay. Okay. Where's the father's name? Om Kumar Lama. Okay. Yes. Now, where's the rejection by the respondents?
That would be page 58, Your Lordship. Operating portion is page 59.
50?
59.
Yes. So both of you not been paid?
No, Your Lordship.
Yes.
Lordship being aggrieved, the petitioner had filed this writ petition.
What is your objection? Why you say it's fabricated?
May it please your Lordship. Lordship, first of all, she is claiming that she is the citizen of India. But all the documents, all the certificate which has been submitted by the petitioner, your Lordship, everywhere is writing that she is the citizen of Nepal and the citizen number has been given there. There is no proof, your Lordship, that she is the citizen of India. And when she
now, when he retired, where he stayed India, he was in Nepal.
He was in India. He died in harness.
He was in India, your Lordship. The petitioner I am talking, your Lordship. The
But if she's never here, then how did he come in contact with her?
Lordship?
How did he come in contact with the
Lordship, it was an arranged marriage.
She was working as a maid servant there, your Lordship.
Where, in Nepal?
No, here, your Lordship. Later, of late. And the marriage certificate, whatever it has been submitted, it has been submitted, your Lordship. I would like to bring on my rejoinder, your affidavit, your Lordship.
Rejoinder, your affidavit?
Affidavit in opposition, your Lordship.
Yes.
Your Lordship,
Your respondent number?
I am respondent number 4.
Okay.
Your Lordship, here, this annexer, page number 25, your Lordship, the annexer 7.
Of your affidavit?
Of the affidavit, your Lordship.
Yeah, YK Tamang.
Yes, your Lordship.
At page?
Page 25, annexer 7. Affidavit in opposition, your Lordship.
1 second. This is the first affidavit.
Yes, your Lordship.
You filed 2 affidavits?
Yes, two affidavit, your Lordship. The first affidavit.
Page 25.
Page 25, your Lordship.
Yes.
Page 25, your Lordship. Here it's saying that the marriage registration certificate issued in Nepal, your Lordship, and the citizenship number, both the petitioner as well as late Om Kumar Rama has been given, and they are showing that they are the citizen of Nepal. But it is a fact, your Lordship, that the deceased Om Kumar Lama was working in Meghalaya police, and he was the citizen of India, and he was never citizen of Nepal, your Lordship. And this marriage registration certificate also shows, your Lordship, that the marriage was solemnized on 4.
I don't understand. What is this 25? What is page 25? This is a death registration certificate.
No, Lordship, it's a marriage registration certificate. Marriage registration certificate of the petitioner.
Page 25?
Yes, your Lordship.
Annexure 7?
Yes, Annexure 7, your Lordship.
Where is written citizenship number?
Yes, down on bottom of that certificate, your Lordship. The registration number of the bride and the registration number of the groom.
How do you verify this?
That's why, your Lordship, that the person, the deceased Om
So, you
Kumar
marry abroad doesn't mean the marriage is valid?
No, your Lordship. Here I want to say, your Lordship, that first of all, that late Om Kumar Lama was a citizen of India, working in Meghalaya police, and he was never citizen of Nepal. Number 1. Number 2, the date of marriage is showing here, your Lordship, 4/12/2006. 4/12/2006, your Lordship. At that time, the first wife was alive, the Suku Lama. Suku Lama was alive, and she died on 11 February 11/2/2011, your Lordship. Before that, she was alive.
Then you'll have to file a suit to
thereafter,
proof.
your Lordship,
Yes.
they have come again with another marriage certificate. Again, they came with another marriage certificate, which is which is Annexure 8, page 27, Your Lordship.
Of your affidavit?
Yes, Your Lordship.
Okay. Page?
Page 27, Your Lordship, Annexure 8.
Yes.
Now here they came, Your Lordship, and here they are claiming that the marriage was solemnized on 3rd 12 2012. 3rd 12 2012. So 2 marriage certificate was produced, Your Lordship. And both the marriage certificate has been issued in Nepal, stating that the both bride and groom were the citizen of Nepal. It is crystal clear, Your Lordship, that both the country, India as well as Nepal, has no dual citizenship facilities. Neither Nepal used to give the dual citizenship, nor the India, Your Lordship.
It's strange. How are the 2 marriage certificates?
Lordship, if I may, Lordship, the first marriage certificate, Your Lordship, there was a wrong date registered as recorded. Thereafter, she had went to the office and got the correct one, got it rectified because they made a mistake.
The signature at this page 26, right? This annexure 725, okay? See, the signature in the right hand corner, what date does it give? It was signed by the registrar. What date is given there? It's written in a local language, I think. It shows
Nepal's date.
that is 6/4. What is this? It's in Nepali, I think. Or is it
something 2074-231 something is that is in the Nepal.
No. This. Where do you get this from?
They know they got from Nepal, Your Lordship.
You produce the certificate first.
Your Lordship, this, I believe they produced it because in the office we had submitted the rectified one and we produced the rectified one.
I got from the office only, Your Lordship. And for that also I have that another, I have filed the additional affidavit. There she has shown and published in the newspaper that my marriage certificate or death certificate date has been mentioned wrongly. So I want to correct it. And it has been published in the newspaper also, Your Lordship.
Mr. Sushila, I was recording the service book.
For that, I'll have to, Lordship, ask her the affidavit.
We'll have to ask the dead man talk now because the living are not giving answers. So whether the dead man talk through service book or not.
And all the certificate has been brought on record. It has been produced before the respondent number 2, the Meghalaya Police, Your Lordship, in the office of Meghalaya Police, by the petitioner after the death of Om Kumar Lama.
See, they're illiterate people, so you can't expect them to be up with the documents and all. But then the facts should be at least clear.
Your Lordship, when late Om Kumar Lama was also hospitalized, the petitioner was the one taking care of him, paying the bills. Even the bills I've annexed, Your Lordship, in the rejoinder.
No, there's no doubt that you were married to him in one way or the other, or that you cohabited and the child is there also, where the father's name has been shown. Only the objection is that...
Father name also, Your Lordship, may be someone else, not I am. And at the same time, the mother is someone else, Your
Lordship. You do DNA testing?
No, it is not possible, Your Lordship. Even the birth certificate of the child has been submitted. The name of the mother is different, Your Lordship. Dolma Lama.
Is that correct?
Yes, Your Lordship.
Doma is the nickname of the petitioner, Your Lordship.
It has never been mentioned in the affidavit, nor it has been mentioned in the petition, Your Lordship.
We have made a declaration regarding the name.
You are Sukulama.
I am the daughter of Sukulama, Your Lordship.
Okay, your father was Om
Kumar Lama.
Your mother died?
My mother died, Your Lordship. And that my death certificate of mother also.
Yes, Mr. Shulai.
Lordship, so far the state is concerned, Your Lordship, there is a nomination as required under Rule 43, Your Lordship, that is Form 1. The deceased, Your Lordship, that is, he has nominated the Suku Lama, and then Rashid Lama, and then Ruchika Lama.
When was it done, the nomination?
Lordship, that has not been made part of the affidavit filed by the state, but the instruction is here with me, Your Lordship. The instruction is here with me.
Why not find part of the affidavit?
Lordship, if that...
It is there, Your Lordship, in my affidavit in opposition, Your Lordship, page number 14, Your Lordship, 15. Page number 15 is there, Your Lordship, the kinder rule of the service book, Your Lordship. Kinder rule of the service book. Where it shows, Your Lordship, that Suku Lama, like my mother, Rachit Lama, my brother, and Ruchika Lama, I am daughter, Your Lordship. It has been nominated here.
So see, what this court is trying to see is whether at the time of this nomination or this kindred role, whether at that point of time, looking at the date, whether the deceased employee was married to the petitioner.
No.
The nomination is before the advent of the marriage.
Yes.
Yes, Your Lordship.
Yes.
Yes, Your Lordship.
That's what it is. So then it becomes very tough.
At the same time, Your Lordship, I was treated here in Najrat Hospital.
Who?
My mother died in 2011, and throughout, due to burn injury, Your Lordship, and throughout I was treated in Najrat Hospital, Your Lordship.
All right.
Yes, it's right, Your Lordship.
That's all right.
Your Lordship, I was treated in Najrat Hospital, but my death certificate was prepared in Nepal, Your Lordship, again.
Who?
By the petitioner, Your Lordship.
Not by the petitioner, by the husband of the petitioner.
By the husband of the petitioner.
Who's death certificate?
My mother's death
Was
certificate.
prepared by the deceased employee?
Yes.
From Nepal?
No, not deceased employee, by the petitioner.
By
the
you?
petitioner.
No, Your Lordship, by the deceased husband.
Your Honor, Your Lordship, I would like to.
Why should she prepare the death certificate of your mother?
Your Lordship, it is evident on record, Your Lordship, my additional
No,
affidavit.
why?
To claim my benefits, Your Lordship. My additional affidavit, Your Lordship.
Yes.
My additional affidavit, Your
The
Lordship.
petitioner was not even aware as such, Your Lordship, of all those.
My additional affidavit, Your Lordship. My additional affidavit, Your Lordship, page number 6, annexer 1. Page number 6, annexer 1.
This is very strange.
Page number 6, Your Lordship, my additional affidavit.
What kind of case is this?
Page number 6, annexer 1.
Yes.
Serial number 8, Your Lordship. Is provided by the office of the Meghalaya Police.
Where is the certificate said prepared by?
Here, Lordship, it said, serial number 8, marriage certificate of Yam Kumari Tamang, I mean to say petitioner, submitted by her after the death of Om Kumar Lama.
Okay.
Then again, Your Lordship, serial number 9, death certificate of Suku Lama, means my mother. Death certificate.
Suku Lama, you are Suku Lama, right?
Yeah, my mother, Your Lordship.
What's your name?
Ruchika Lama.
Okay.
I am respondent number 4. So, death certificate of Suku Lama submitted by Yam Kumari Tamang.
Where is that one?
Death certificate is annexer 1E, Your Lordship, page number 15. Page number 15.
Oh, yes. So you all stay in Nepal, that means? All of you?
I died here in India, Your Lordship.
You died here in India, but then both
they have brought everything.
Were in Nepal.
And my death certificate
so
also.
Even you are from Nepal, that means?
Your Lordship.
Yes.
Your Lordship, my death certificate, I have 2 death certificates they have produced.
No, that means you also died in Nepal. You are from Nepal only. She's from Nepal also. Then?
Your Lordship, I have a discharge certificate of the hospital, of Najrat Hospital, Shillong.
Yes.
I have death certificate.
You can obtain anywhere. If I've had cases in this court itself where the person died in Bihar and death certificate from Bagamara. Policeman only.
I was
so policeman, what they're doing, God knows.
Your Lordship, I was treated in the Najrat Hospital. The discharge certificate is here.
Sukulama.
Sukulama. I have in.
Then why was the death certificate prepared in Nepal?
That's why, Your Lordship,
that died in Nepal.
They are showing that I died in Nepal.
Where is that? It says.
My additional affidavit in opposition, Your Lordship. My affidavit in opposition.
No, we'll see that death certificate again. She died in 2010.
Died 2011, Your Lordship. But they are showing that my mother died in 2010.
And this certificate issued 2017. I think, Mr. Shulai, this matter.
This is Your Lordship. Lordship,
I don't think you can shed any light, or any of you.
in view of the complex situation of the case, Your Lordship, may I request Your Lordship relegate them to the civil court.
They'll have to go to civil court. All these documents, how?
Let
In
them,
the realm of private international law.
Let them establish the right in the.
Both of you also. You are from Nepal also, it means.
Your Lordship, I have the school certificate here.
Doesn't matter.
That I am from here.
Now it is from Nepal.
I am from here. I have the discharge certificate from the
You have the
hospital.
certificate from Shillong also?
Yes, Your Lord.
Where's that?
Birth certificate I don't
Not
have.
death certificate.
My death certificate is not there, Your Lordship, here.
From Shillong?
I have the discharge certificate.
No, where's the death certificate that you issued by authority here?
That is issued by one doctor, Your Lordship. And that is dated 15 to 2011.
Where is that? No, issued by doctor will not suffice. Where is that?
In affidavit in opposition, Your Lordship.
Oh, that's everything. Both of you are sailing the same boat.
Let them go to civil court.
1 second.
Let them establish their entitlement.
Discharge on request.
Yes, Your
That
Lordship.
means you have to
Annexer
Nepal
1.
after that. Yes.
Annexer 1. I was
Where's the death- and where's the
discharged
death
on
certificate?
5 to 2011, Your
Where's the
Lordship.
death certificate?
And their certificate is Annexer 3, page 17, Your Lordship.
Okay. Who's the doctor?
Dr. Mrs. S.D. Sengupta. Expired on 11 to 2011 and certificate was issued on 15 to 2011.
Where is it expired?
Expired at Happy Valley Medan writing, Your Lordship.
Where is written?
In that certificate only it's written, Your Lordship.
Read it. Read it. Read the certificate. Read loudly. What does it say?
This is to certify that
Yes.
I have examined Suku Lama, wife of Om Kumar Lama, age 33 years,
Yes.
old, burn case and depression
Yes.
on 11 to 2011 at 2:30 a.m.
Yes.
in Happy Valley Medan writing at her residence and found expired.
Yes.
She has suffered from burn of her lower parts of the body and depression.
It's not death certificate. This is issued by a doctor.
Issued by doctor is written here that and found expired.
Then from Darbar Shillong you got one certificate.
Yes, Your Lordship.
Then
I was discharged from Nazarat Hospital on 5 February 2011.
should we dispose it off?
Whatever the case may be, Your Lordship, I brought whatever the facts is there.
The more facts are brought, the more confusing it gets. Enough. Don't bring any more facts. Better you take a chance with that in the civil court. These documents are proven. How can it two death certificates? Fact them of marriage. You're both Nepali citizens. That means.
No, Your Lordship, I born and brought up here. Even this is Om Kumar Lama, also born and brought up here. We have the school certificate issued by the St. Anthony's College.
Where is the marriage certificate?
My marriage certificate is not there, Your Lordship. I am only on document, on the service record.
On?
I am on the service record, Your Lordship.
Fine. Where is the marriage certificate?
Marriage certificate is not there.
Wife, whatever it is, wherever it is from, might be married in Las Vegas also will be recognized.
But I am on the document, I am on the service record, Your Lordship. I am on the service record.
You'll have to go. I think I'll give you time to think over. We'll list it on Monday. We'll dispose it off otherwise. No relief before coming from this court. On this undisputed facts, we can't pass any effective orders. Heard at some length, parties to list the matter on Monday, 25th. Parties to obtain instructions.
Item 30.
Otherwise, there's no point in the Soyan.
But your lordship, I am the legally wedded wife, your lordship. I was taking care of him.
That is neither here nor there. He died in two places.
No, he died in Shillong.
He died in Shillong. The first wife died in two places.
That I'm not aware, your lordship, because it was...
Exactly, because we're not aware. And you're both citizens of Nepal or you're citizens of India?
Apply, your lordship.
Yes.
Deeply obliged, your lordship. This matter
Resolved.
for time. This matter relates to that Malay Somat same ship, my lord.
We said it will be resolved before the council. That's what the submission last time.
Yes,
What
your
happened?
lordship. Your lordship, actually today they were supposed to sort for time, your lordship. That was the contention that we came with today, your lordship. So
I'm told that the session is sitting sometime in October.
Okay,
So
this is matter after 3 weeks. You have to
Lordship,
await
right, lordship.
any outcome of the resolution process.
Deeply.
Yes.
31.
Excuse me.
This matter pertains to non-declaration of result.
Your Lordship, this
To come with instructions, Lordship.
So, Your Lordship, just I have a discussion with this official. They are saying this after this interview took place, when this witness come out and subsequently petitioner has participated in the interview, next interview. So he was not successful in the next interview. So now he is challenging after that. That's first interview took place, the petitioner declared the result and for the particular purpose. So whatsoever I just discussed with the official. They are
What do you mean we discuss? We want instruction, written instructions. You can't discuss a cup of tea and say those are my instructions.
So, Your Lordship, verbal instruction is there that you receive in this.
Please, Mr. Devnath, you are a veteran. You
so
know how to avoid, but then there's a question of there's a limit to avoiding. Giving it like concrete instructions. You're supposed to have instructions whether why result not declared. That's all. The exams are over. Why result not declared? You come with instructions. These are the reasons A, B, C, D result is not declared. Then the court will examine that and see whether your non-declaration is justified or not. That's all. What remains? Having discussion doesn't mean anything. When you have discussion in the tea shop, must be, because discussion means what?
So let's written warnings.
Just take down Mr. R. Devnath has been unable to obtain specific instructions as to why the results were not declared. That is the last order was where you thought that was on 10-8.
10-8.
You're taken for time is right?
Mr. Agarwal has been able to obtain specific instruction as to why the results were not.
In spite of repeated opportunities being given and stuff. He is therefore direct to obtain the same. He is direct to obtain instructions within 2 weeks, feeling which the concerned officer will have to appear in court personally to explain the situation, clarify the situation. List after 2 weeks, copy of the order be given to the learned CGC. Let officer come. We can have a discussion here also.
33.
Yes.
Lordship.
Yes.
Lordship, this was a matter we had commenced hearing on the last date also. Then Lordship the Lordship had to go, so it was stopped. Lordship, we are educational institution. I'm the managing committee of an educational institution by the name of Christian Academy.
Okay.
Now, Lordship, sometime in the year 2021,
yes.
the Employees Provident Fund organization, they sent us a summon that there are certain amounts which are due, totaling to a sum of rupees 19,09,462, divided in two parts. Part A being 5,49,277 and Part B being 13,60,185. Specifically at Lordship, page number 42. is the summon. Page number 44 onwards is the annex.
25, 23.
Lordship 23, 11, 21.
Yes.
Lordship, page 44 onwards is the annexure to this summon, where they have mentioned the amounts.
44.
44 to 48.
Okay. Excuse me, yes.
Now, Lordship, this is for a period from 1993 till 2006.
Okay.
Lordship, this summon was served to us in the year 2021, never prior to it. However, Lordship, in the middle, sometime in the year 2011, Lordship, we had also been served a summon for a default which was around the period of 2008-9, which we had paid. During that time also they never...
93 to 2006, correct?
93 to 2006, Lordship.
Yes.
Prior to this, Lordship, in the year 2014, we paid a sum of money for a period between September 2011 to March 2013.
Where is that?
Lordship, page 54. Second paragraph, Lordship, page 54.
Yes. 54 is your letter.
My letter to them, this is not disputed.
No,
The
can you tell me
contention
this thing?
that, Lordship, para 2, we mentioned that an earlier occasion, in view of the delayed payment, we were served notices for damages and accordingly promptly made the payment, which for the period September 2011 to March 2013, an amount of rupees 18,766 was paid in June, and for a period September 2015 to December 2016, an amount of rupees 3,62,535 was paid in September 2017.
Okay.
Now, Lordship, why I'm drawing a Lordship's attention to these two payments is because when these two summons were sent, at that time also there was no mention, we were not intimated of anything between 1993 till 2006.
Right.
Suddenly we received this summon in 2021 and we reply and respond to it, and we have been repeatedly asking them till date that you have received this calculation at Annexure A, page 44 to page 48. All we were requesting is that, Lordship, on what basis have you come to this calculation? We are an institution of repute. If we have to pay, we will not shy away from it. But this is not money of some individual, it's the money of an institution which is being reinvested into the upliftment and infrastructural development of the institution, which they are shying away, and they have not been able to tell us on what basis have they reached this particular calculation.
What reply did he give?
Lordship, the reply in a nutshell, what they have tried to say is that this Annexure 3, page 42 to page 48, this is the complete details that they have, and this is the details on which they have assessed.
On your letter, this is 22nd to 2022. What did he say?
Lordship,
They haven't replied to this.
They haven't
This is
replied.
Annexure 7.
They haven't
Annexure
replied.
8.
Each time we have asked them, they have said this is the summon, Annexure 3, this is the detail and this is on which we are assessing it. At last, Lordship, what they did is, on 15th of December also we wrote a final letter to them, requesting them to give us the complete detail, and we also said that if we are bound to pay, we will pay. They went ahead and passed the impugned order, Lordship.
Where is that?
Page 70. Page 72, Lordship.
Did he freeze your accounts?
Lordship, they directed the bank to debit the amount and bank has accordingly debited it.
Hmm.
and they have imposed an interest on his lordship amounting to 5,49,277 for a period between 1993 to 2006, when they have already issued us two notices for payment in the year 2014 and 2017, wherein there has been no mention of any outstanding dues that we had for a period between 1993 and 2006. In the rejoinder also, lordship, which they have filed, they have neither given any, we have raised these issues. In the counter affidavit, lordship, they have not been able to tell us the number of employees that were there, the details of the employees against whom they have sent us the summon for making these payments. Nor have they been able to give us any of the heads under which they have charged us. So if we are required to pay, lordship, we will pay. But all
the one's already been taken off.
Already been taken, lordship, on the 17th of February.
This year?
Lordship.
When was this matter filed?
Lordship, it was filed
after the withdrawal.
Lordship, it was around the time we had filed a miss case, but we missed the bus by a day or two, so the money got debited.
No reasons for coming. So why the escaped this? What do you call it? Escape the for this period 93 2007. Why did they escape?
This is not escaped amount, lordship. This is delay payment, lordship. Payment, it is not escaped. The amount is they have paid but delay. Suppose, lordship, in if we come to page 44. They have paid in the amount is of due date is 1993. They paid in 2003. They have paid. It is not escaped amount, lordship.
If that means for these periods all has been paid. It's only on delayed payment.
On delay payment.
What does the law say about that?
Lordship, that is
regard
why
to interest.
Yes,
and
interest.
penalty. What does it say?
14B is for the
7Q 14B.
For 7Q 14.
Yes. What does it say?
Lordship, I am little bit handicapped.
You didn't bring your Pay Act also?
I asked my colleague, but he missed.
That is not. You can never blame your colleague. That is very unfortunate. What does it say?
Lordship, we have reproduced section 7 and section 14 in our petition. Page 12 and page 13.
Even if delayed payment, now 2003 not a last. Now let's see the chart again. 42. Sorry. Let us see.
Lordship, we had also asked them if there are any challans with them.
Now your interest period you're charging for only for a particular period from 93,003.
Yes.
It's not for.
It is not for. It's not the escaped amount. They have
So
not
you're
escaped.
saying okay, fine. The delay is. Just break it down for the court.
Lordship, it is 15 to 1993 first. They have paid.
So you say contribution is 12,000.
Yes.
1 lakh, no, 1,25,490.
Yes,
Right.
1,25,000.
Then AC1 and AC10 is 4,510. Then it's 23107Q.
Then 14B is 14B is amount is 1,54,25,000, and under 7Q it's 9,000. 95,000.
So you come to with the other amount, it comes to 1,30,000.
Yes, 1,30,000.
40,000, 40, 39, 36.
The total amount comes to in the page number 45. Page number 45. Total amount is there. 4,55,911 under 7Q.
Page?
It's page number 45. The total amount is there. Each page is page number 46 also, down below it is total amount. Page number 47,
Well,
down
you can see
below is
that,
the
yes,
total
the
amount.
10,85,000, 14B, 7Q, 45, 4,55,000.
Then same 40 page number 46. Also down below is total amount 7Q 14B. Page number 47 also, and page number 1848 also.
Okay.
And Lordship, with regard to page number 54, the annexure, this annexure we could not reply because the letter was not addressed to us. It's addressed to Guwahati. So we have not received the letter.
You see, one thing, if your amount last was paid in 2007, right? These are the
Yes.
periods from 93 to 2007. 2006, we say last payment made on 30th March 2000. Why was notice not given earlier? Why was it issued as late as 21?
The Lordship, the notice was not issued earlier because when the matter came before this, when the matter came before us, then thereafter we have
Came before whom?
means like when we have noticed.
But you're the person who's supposed to see all this. What do you mean to say that? Intra-departmental is some problem?
I am exactly not sure, but because of what this 2007 from 2007. But then the thing is that they have paid.
2007
They have
is the
paid.
last
Yeah.
date they've paid, right?
Yes, they have.
And then for these amounts, you're asking for interest and damages by letter. Okay, fine. It's for the periods for that time.
Yes.
Now you're asking into 2021.
Yes, we are asking in 2021.
Law
for the-
permits that.
Because even the act is not saying that there is time barred. If anything, if any finding comes up, if they have paid.
You have any authority on that?
Yes, the act does not give any time barred.
Does he have any authority on that?
Authority I have to see, but there is no.
Because of authorities. There are some cases where they have reduced the penalty. That's all, yes.
Lordship, this is my whole case. We have not been able to understand.
Understood.
How have they come to this calculation?
They have come to this calculation because whatever is as per the calculation, the question of delayed payments. It was not clarified why delayed payments have been there, but like for the period, suppose 93, it was paid after 10 years, 95, 2003, then 99 is paid 99, 150 rupees, 2000 paid 2000. Now the heavy delays is only for the period 1993, where payment was made 2003. Then the other periods seem to be in order except for like marginal delays where you've been given 37,000, some case to,
Lordship, in
small amounts.
2016, not knowing that this summon would come, 5 years prior to this summon, we filed one FIR.
No, but there's no impact on you financially in the sense that it is not, the interest does not run from 93 to 21.
Lordship.
They're calculating interest at 12%, I think. Correct?
Pardon, 12%.
Yes, only for those periods where the delay in the payment of that period. Now the computation of the delay is nowhere.
Actually, we
Now,
asked
how do you
them-
see it's delayed?
We asked them to
Now,
provide
how
us the
this is
challans.
system generated printout, correct?
Yes.
Now, how was the delay calculated, and like where's the invoices to show that the payment was made in 2003,
because,
not
once-
earlier?
Lordship, that is what we asked them to give us a copy of the challan. Based on, because 93 they did not have a computerized system where they could have table data. They have table data at a later date. So they are bound to have those copy of the challans.
Can you produce the challans?
That is what we have asked them.
Lordship, here what happened? I'll
If you
ask
can
from.
produce the challans,
I'll ask from the
then they what do you call it? They will be bound if it's correct. Like for the period 93, they paid 2003.
2003.
Then there's a delay of nearly 10 years.
10 years.
Yeah, so that you've inflicted, like 13 lakhs.
Yes.
Oh no, 1,30,000.
1,30,000.
Yes.
For 10 years.
As penalty and
As
interest.
as penalty and interest.
If I can have Lordship at page 26, para 21 of my writ.
Page
26, para 21.
Interesting case, yes. Yes.
Lordship, if I may, from the second last line.
Yes.
Para 21, page 26, Lordship. Second last line, if I may.
Yes, so that
The petitioner begs to submit that I am willing to pay, Lordship.
No, that's not a question of you not willing to pay. The question is they need some clarification.
Lordship, actually, from this daily calculations, whatever the thing is, that it is already clear that they have paid it late.
Fine, but then it's given satisfaction. Now they don't have the records by themselves. I think it's lost or something.
We have filed FIR in 2016 that all our records are lost. See, 5 years prior to this. And we have also brought this to their notice, Lordship, that we don't have the records. Please provide us the records, and whatever we are bound to pay, we will pay.
Lordship, actually, this based on these challans, based on these calculations, it is derived at.
Exactly. No, where we want to see where you derive this calculation from. Simple as that. It's not a rocket science. Something very simple. You have given them a sheet where you said that for 93 you pay 1,003, for 2,000 you pay 1,002, and so these are the amounts. This is interest, this is the penalty, and this interest. 7Q 14B. This is the interest, and this is the penalty. Right? Damages, whatever. Fine. So these are the amounts you pay up. Now a person is entitled to know that they say that whether there was any delay, or whether delay might be delay, but whether it's for those days that you've shown there in your summons, in your demand note.
Lordship,
Because it's unlike other cases. It's not unlike other cases. Different.
Other cases.
It's non-payment, but this case is different.
Yes, this case is different.
On 10 June 2022, Lordship, Annexure 6, page 51, when we had replied to their summon, therein also we have never said that we won't pay or it is a wrong calculation. All we have asked them right from day one is please provide us the details upon which you have been able to.
Can you do that, MS Bhattacharya?
I'll take instructions.
You have to.
Yes.
These are going to take instructions.
I'll get instructions on this. That
We are all having these open-ended hearings. The other hearing won't go anywhere. Even I thought we'll finish this one also. I will reduce the penalty by half, and interest also in the failure to produce the documents. There are the cases you see. There are some cases where the penalty has been reduced, going against the grain of the act also.
I'll get the instructions. I'll get the instructions.
Take down the main grievance of writ petitioner in instant case is that the demand for payment of interest and damages which has been generated by a computer does not clarify as to how the amounts were arrived at. Stop further. The period for which the delay or default in payments has occurred refers to the years 1993 to 2007, for which the demand has been made only on 23/11/2021. Stop. Next paragraph. In his view, the matter, the MSP Bhattacharya learned counsel for the respondents prays that she allowed to produce the payment vouchers which is the material on which the summons note, the amounts shown in the summons have been generated. How much time do you require?
3 weeks.
What's the matter of the 3 weeks is?
Lordship, at page 42, they are charging me
It's all right, Mr.
37% and 25%.
Let them see, because like they have 12% interest.
37%, Lordship.
Lordship, it is there is a time 12%, but the timing, the duration also is calculated.
So for a period from 2008, they are
I
charging.
will give it to some expert. I'm not good at number crunching. Yes.
34?
Obliged, Lordship.
I'm taking up this matter alone. Item 35, Lordship.
34, 35?
34 and 35.
Who's Mr. Lorenian? You, Mr. Lorenian?
Laurinia.
Yes, sir.
Please, Your Lordship. I am working in the office of the Executive Engineer.
You're asking for realization?
Yes, Lordship. I am working in the office of the Executive Engineer, PWD Roads National Highway Shillong Bypass Division, Lordship, on an ad hoc basis since August 2001, Lordship, and my co-petitioner, Lordship, since 1st September 2001, Lordship. So my service has always been extended, Lordship. Even till date, I have always been working. There's no break of service in between, Your Lordship. In Annexure 2, Your Lordship, page 34, the letter issued by the Joint Secretary.
Page 34.
That's a type copy, Your Lordship. It stated that the incumbents have already served for about 4 years against a sanctioned post, so the services may be allowed to continue, so as to not cause any hardship to the incumbents concerned, and the District Selection Committee need not be informed at present until further decision arrangement is made, Lordship. So, and in Annexure 3 also, Lordship, page 35, considering the heavy pressure of work in the division, the incumbents are also allowed to continue in service and to be retained, Lordship. And I'm also retained till date, Lordship. In page 37, Lordship, letter dated 24th August 2005, issued by the Joint Secretary to the Government of Meghalaya PWD Department, Lordship, has prayed for the consideration of regularizing of service against a sanctioned post, Lordship.
Where is that? 37.
Yes, Lordship. The next page, Lordship, page 38. In the remarks column, Lordship.
Yes.
They have already stated that all the incumbents have been accommodated against a sanctioned post.
Where is it written?
In the remarks column, Lordship.
All the incumbents were
accommodated against sanctioned posts, which are retained.
I mean, serving a sanctioned post, yes, correct.
And
yes.
In page 40, Lordship, in another letter dated 13 November 2009, issued by the Executive Engineer, National Highway Shillong Bypass Division to the Administrative Officer, stating that there are 2 numbers of vacant posts of Section Assistant against a sanctioned post, Lordship, where my name is also is included, Lordship, in the list. It's the next page, Lordship. I am also entitled to increment, Lordship.
You're working ad hoc only.
Yes.
It's no fear, is not.
Yes, Lordship. And in page 55, Lordship, letter issued by the Personnel Department, 23rd June 2022. 23rd June 2022. Page 55.
Yes.
Letter issued by the Deputy Secretary to the Government of Meghalaya, Personnel Department, Lordship, where the Cabinet had regularized by the Cabinet, Lordship, in a meeting held on the 15th of March 2022. And the conditions laid down, Lordship.
So that is the thing. No, what this court saying? What happened after this?
Lordship, my salary was withheld, Lordship, since March 2022 till date.
No renewal of your appointment.
There's no renewal.
We are
No further
working, Your Lordship.
extension.
Even after February 22, also I'm still working.
The
till
matter
date.
didn't go for the cabinet.
They did. Pardon?
The matter was not police for the cabinet.
The cabinet had regularized, Lordship. My list, my name's included in the list, Lordship.
In the this.
Yes, in the regularization list.
Where is that? Name is at number?
My name is in bearing number 84, Lordship. 83 and 84, Lordship.
Oh, you're not come against regularization. You come for non-pure salary.
Yes, Lordship.
Yes, why? What is the problem?
Your Lordship, they were never, the temporary service was never extended beyond February 2022, Your Lordship. They were appointed in a regularized work charge posts which lapsed with the death or the superannuation of the previous employee. It was not a sanction, regular sanction post.
Whatever it is, then give them some effect of some.
But they have not. We have given them an alternative. Either they take over as muster roll employees or on contractual basis. Out of
Why
the
do you
12,
say those are the sanction posts? You mean to say that the earlier post died with the
incumbents.
No,
That is what is.
the section assistant.
Yes, they were section assistants and they died with the. So they were not extended further on the. We have given an affidavit.
Yes.
During the meeting, prior to the meeting, Lordship, held by the Cabinet 15 March 2022, all the relevant documents was tabled before the Cabinet, Lordship.
Right, but how can you go against this Cabinet decision?
Then, Your Lordship, the approval has been made subject to certain conditions that there should be sanction posts. It is very much clear, Your Lordship.
Let's see affidavit.
Affidavit is here. This is the entry.
Where do you say that specifically?
At page 19, Your Lordship, this is regarding that cabinet approval.
Okay, that's what he's already read.
List of at page 20. So the conditions are here at page 19. In inviting a reference to the subject cited above, I am directed to say that the following ad hoc appointees under your department are approved by the cabinet for regularization, subject to the conditions that a regularization against sanction posts only.
Yes.
Number one, we are saying that their posts, these two people were not on sanction posts.
They're ad hoc before 2007. They'll come on, even if they don't get one, they'll be under two.
And it was in the lapse post, Your Lordship. It died this.
No. With regard to now they'll come in consideration under two. The ad hoc appointments made on before the 1st December 2007. They will fall under that if your submission is correct that the post died with the earlier
Yes.
incumbent. Where you say that?
In my affidavit, Your Lordship.
Where?
From the very beginning, we have been saying that only, Your Lordship. At page 2, Your Lordship, the preliminary submission, it is submitted that in the year 2001, due to certain requirements, section assistants were appointed for a brief period of 3 months on a purely temporary basis.
One second. Page 2.
At page 2 of the affidavit, Your Lordship. Then they were extended for a considerable length of time due to the pressure of work. And then at para 3, Your Lordship, it is submitted that in the year 1999, which was before the petitioner was actually appointed, the Public Works, Road Buildings Department Administration Branch via letter number so-and-so, dated 20th September 1999, informed the Accountant General Meghalaya that the department has been accorded sanction by the Governor with regard to the issue of creation of posts under different categories of various PWD Road Building Division and for regularization of work charged employees. That means of those who were working prior to 1993, Your Lordship. So they were regularized. And then, Your Lordship, the copy of the said letter, it is stated that in the year 1999, a policy decision was made by the government, firstly for regularization of work charged employees who had completed 5 years service or more on or before 12/7/93, and secondly, creation of posts under different categories of various PWD Road Building Division, particularly for the pension benefit of work charge employees, which gets lapsed after the retirement of the employee. In this regard, specific instructions were given also to the Chief Engineer Meghalaya that consequential vacancies in the work charge establishment would stand lapsed and no new appointment in the said post should be made. The copy of the letter was also marked to all officers of the PW department in various divisions in Meghalaya for necessary implementation. Then in the year 2001, Your Lordship, appointments were given of section assistants against a regularized work charged post, lapsed post, and not against a permanent sanctioned post. Therefore, being a temporary post, the said post was not retained as the same was created particularly for the pension benefit of work charge employee, which gets lapsed after the retirement of the employee. In other words, it is submitted that these posts were created only for regularization of the service of work charged employees who had completed 5 years of service or more on or before 12/7/93, and that consequential vacancies would stand lapsed and no appointment should be made. Hence, appointments given in the year 2001 was a non-sanctioned post, and after each retirement of the regular employees, the post ceased to exist and the department cannot retain the employees thereafter.
Now what you see in this in the para 9, page 6,
Para 9, Your Lordship. It is submitted that out of 12 incumbents in the office of the PWD, National Highway Shillong Bypass Division, 9 is accepted because we had offered them alternative employment. Contractual basis or as muster roll employees. Now, out of that, 9 of them have accepted as contractual employees.
Now, but one thing is that when they were serving from 2001 against whatever they were committed against a sanctioned post, were they paid a regular scale as per a sanctioned post?
Yes, they were paid regular scale.
And how was that done for 20 years? If 2002, 2001, upon 20 years, they were given a regular
scale of pay, isn't it?
Then how to come one fine day, wake up and find that they were working against non-existent posts?
You see, Your Lordship, because that post ceased to exist at that point.
At
that point of time,
when they were appointed, it should have been work charge. I mean, ad hoc, whatever, or as a casual worker. That means that they were appointed against a sanctioned post. They were paid. Then how did they reach a salary all the while that the post died with the incumbents?
No, after February 22, their post was never, their tenure was never extended, and they were not paid.
From 2001. How would he paid against a sanctioned post? How would he paid? Where did the money come from?
No, that was not a sanctioned post, Your Lordship.
If it was not sanctioned post, how would he pay that they given a regular scale? How?
Let me find out from them, because we are also not very clear on that point, Your Lordship.
And what kind of offer he gave them to revert to contraction of appointment?
That is.
I mean, put them back the same against a non-existent sanctioned post. You renewed every 59 days.
Flat rate of 25,000.
That's. Now that means what was your pay according to the scale? What do you paid last with last salary, Ms. Nongpur? How much did you get?
It is there
in my rejoinder, Lordship.
How much you get?
I had a touch.
I'm not seeing rejoinder. Yes.
Lordship, yes. 54.
How much are you drawing?
54,000.
How much?
54,023.
Exactly.
In page 44, Lordship. My rejoinder, Lordship.
What about civil consequences?
The head of accounts.
54,000 now you say kick them out, pay them 25,000. They were non-existent post. How will you recover that money that's been paid for 20 years to these people? From whom should be recoverable? Then from the officer who has paid them or signed the money, that should be recovered from them. Court will pass orders. If that is a stand, then recover from them. For 20 years now
Lordship
they
has
paid
got
them.
A point.
Yes,
Lordship
has
got
to
a
be
point.
recovered.
So
That's
let me
public
find
money.
out whether they were, on what basis they were being paid and from where they were being paid.
Your Lordship, the head of account also differs, Lordship.
Then it is recover from whose pocket then? Public money.
But everywhere they are saying that they
20 years. Drawing 54,000 now.
Therefore, in this connection, according to good office to accord required sanction to enable this office to disburse their salaries as work charged staff, and the expenditure to be chargeable to the head of accounts. Something is not.
One fine day, you're working every day, suppose under sanctioned post, getting 50,000, taking home to your wife. One fine day, you see, you work something, you take zero money or take 25,000.
That is.
And then
I understand your concern.
And you recover from them. Next will follow us that from 20,000, half will be recovered towards the salary that they were paid. Now what will happen?
Let us
very strange.
Yes.
But you know why this happens? It's anyway. And why did they say that don't intimate the district
selection? I am also surprised at that. Why?
The vacancy does not exist anymore. There's no question of intimating the DSC.
No, even it surprised me also that this lady, the joint secretary, who happens to be the mother of the petitioner, says let their service continue.
The mother of the petitioner?
Yes.
All in the family.
Then she has said that let them continue, but don't inform the DSC.
No.
So
there's no question
from
informing.
there onwards, all the mistakes started happening.
There's no question of informing the DSC. If the post is non-existent,
then why should you?
Why should you?
So because of that, Your Lordship, from then on, the errors have started occurring.
How will you correct it? How will you reconcile it?
The errors have started occurring.
Now, like it, rightly or wrongly, they've been working for 20 years.
20 years.
Lordship,
And this letter was issued in 2005.
Issued a letter for creation of supernumerary posts.
Who had issued letter?
the chief engineer, Your Lordship. In my rejoinder, I've attached it, page 46.
But no supernumerary post was there. Where's the
Anyway,
supernumerary post?
after hearing some length, MST Yangi AAG please not to obtain further instructions on the pay that was afforded, the manner of engagement appears afforded to the petitioners. Just after 2 weeks, yes. Today is open-ended, no hearing can seems to be concluded.
37.
Stop. Yes.
37.
Huh?
37 to 51 all connected. 37 Mr. Gautam is appearing. And the rest I am appearing.
Who's appearing 37?
Mr. Gautam, Kisi Gautam.
When Mr. Kisi Gautam?
He was here. Paucity of time. If my lord can have it either on Monday or Wednesday, my lord, next.
Okay. After listen next week. You will argue it. You'll have to argue it, yes. If he's not here next on the next date, Mr. Gautam. Yes. Huh? Where's Mr. Sen?
Your Lordship, if the matter can be taken up in the second half, Your Lordship.
Okay, second half.
To Your Lordship.
After, no, not 2:15, 2:20. Yes. Tell him to be here. You're ready.
Alright.
Yes. Don't disappear. Last time the court came, disappeared. Yes.
Please, Your Lordship.
He's finished, no?
He's finished. Not subject to reply. What my senior says. In fact, my learned friend has raised, my lord, many, including, my lord, technical objections.
Yes, you have to meet them.
Yes,
Mr.
Yes.
Sen.
Yes, yes, Your Lordship.
It was quite crucial in the view of the court.
Now, my lord, this claim for, my lord, the claim for or introduction of, my lord, UGC pay scales, my lord.
One second. Commission. Concave अपन लिप्सो का फैन बंद करोगे ओके Yes.
Now, my lord, the UGC pay scale, my lord, have been introduced, my lord, following the issuance of a, my lord, letter dated by the Ministry of Human Resources, my lord.
31st 12/2008.
My lord. That is the most crucial thing here. Now, what I want to say, Your Lordship, this is a decision in the form of a scheme, my lord.
Today is 20th.
Today is 20th, my lord. My lord, in the form of a scheme, my lord, issued by the MHRD. Issued by the MHRD, my lord. Now, if Your Lordship, because one point my learned friend was harping that it should be funded by the UGC, should be funded by the central government, my lord. There is no dispute. In the opening paragraph, again, my short paragraph I will read. I am directed to say, that is at page, my lord, 7922 of the volume.
Appendix.
My lord, this has been, my lord, formed a part of the subsequent regulation made by the UGC. Now, as Appendix 1. Now, my lord, with the first paragraph, Your Lordship, sir, I am directed to say the Government of India has decided, after taking into consideration the recommendation made by the UGC, based on the decision taken in the meeting of the Commission on such to revise the pay scale of teacher of the Central University. The revision of the pay scale of teacher shall be subject to various provisions of the scheme. Revision pay scale as contained in the letter of the regulations framed by the UGC in this we have in accordance with the scheme given below, my lord. Now, it's very clearly, categorically say open to central universities. My lord, others are not in the pictures. Now, my lord, kindly, Your Lordships, come to, my lord, the applicability. My lord, this applicability is at page 7935. Now, this scheme is normally for central teachers, deemed universities, and those funded by the UGC, no doubt about it. Now, if Your Lordship come to the applicability of the scheme at page 7935,
yes,
my lord, one I read, the scheme shall be applicable, yes, Lordship got it, shall be applicable to teacher and other equivalent candidates of library, physical education, central universities and college thereunder, and the institution deemed to be universities whose maintenance expenditure is met by the UGC. The implementation shall be subject to the acceptance of all conditions mentioned in this letter as well as regulation to be framed. Regulation to be, when this letter was issued, my lord, regulation was not there. To be framed, the future tense has been deliberately used. In this we have, university implementing the scheme shall be advised the UGC to amend their relevant statutes. So now here again it is repeating, my lord, it will apply to central university, deemed university, and those universities and college funded by the UGC. So, my lord, state government, state colleges, deficit colleges do not come here, my lord. It's not covered by this. Now, Your Lordship, the next page, 7936. My lord, subclause Roman 6, Your Lord, Roman 5. Roman 5, Your Lordship. The scheme may be extended to the university, colleges, and other higher educational institutions coming under the purview of the state legislature, provided the state government wish to adopt and implement the scheme subject to the following condition. Now, my lord, here they have created an exception, and Lordship will kindly note the language. This is not mandatory. This is an option. My learned friend has referred to many decisions where the Supreme Court has also held, my lord, and discretion has been given to this day. I don't dispute, my lord. State government could have opted out, my lord. Nobody has forced them. So a discretion has been given to the state governments to extend it to the teachers of the government colleges and deficit colleges. But in case they, my lord, introduce it, this would be subject to the condition laid down there. No, what are the conditions, my lord? One is funding for 5 years, for a limited period. For 5 years, funding would be in the pattern of 80% by the central government, 20% to be borne by the state government. Now, other condition is this, my lord. State has been given a liberty, my lord, as regarding the date of introduction of the scheme. Now, normally, my lord, the central government, my lord, introduced this with effect from 1/1/2006. Now, state government, they have been given a choice considering the local condition. You could choose some other date. But here, my lord, we will not go into it because state also, my lord, admittedly, is not a dispute, your lordship. They have followed the central cutoff date, that is 1/1/2006. They have not. Another choice was given to them, my lord, regarding the pay scales introduced by the scheme. They said if the state government, considering the local conditions, they want to give something higher than what we have prescribed, they are free to do so. But in that case, that expenditure would be borne by the state government.
Yes.
Now, my lord, here this is not very relevant because the cut-off date, state government has not changed. They followed the central government. So, for the pay scale concern, my lord, they have not done any variation. They are following the what have been prescribed by the central government. Now, my lord, at a time, since my lord, I am referring to these booklets, lordship will kindly come to regarding 7934. My lord, what my learned friend contention was this, that
7934?
7934.
Back, go back.
Yes, your lordship.
Yes.
No, my learned friend's submission is this thing, that since the petitioners have been insisting, all the conditions, since the state government has introduced this scheme, accepted this scheme, they are under obligation to, my lord,
they're not
follow,
giving pension.
Yes, including pension.
Yeah.
Now his question is pension. They are not eligible for pension. Lordship will look into the languages, very clear and categorical. Pension for teachers and other cadres in UGC maintained institution in receipt of pension. Lordship will listen one word. In receipt of pension, that means teachers who are getting pension.
Yes.
In receipt of pension, that means who are getting pensions. In their case, this will apply. It will obviously not cover, my lord, those institutions which are not, my lord, covered under, my lord, the normal pension schemes. They are not covered under this clause. Only those who are getting pension already. In their case, it will apply. So, what my learned friend submitted that in the case, my lord, we insist for increments, and then the question comes that we should also insist, my lord, the state government will also come under obligation to implement this. No. Admittedly, deficit schools, they have contributed provident fund and other things mentioned. So these will not apply. This is only for those teachers, my lord, who are already drawing. Now, my lord, again, your lordship, if I can come to 7932, your lordships. Other terms and conditions, my lord, that is increments, where, my lord, my case is. (7932), your lordships. Other terms and conditions, increments.
Yes.
Yes, my lord. Lordship will kindly come to clause 3, 8.3, in the bottom. The number of additional increments on placement at each higher stage of AGP shall be as per existing scheme of increment on promotion from lower pay scale to higher pay scale. However, in view of considerable rise in the effective pay between the two pay bands, there shall be no additional increment on movement from pay band of rupees such and such to such and such. Now here categorically they are provided for movement to each, to a higher economic grade pay, they would be entitled for an increment, clear and categorical, with an exception movement from this particular pay scale, not AGB, from this particular pay scale to pay band to the pay band of 37,400 to 67,000, my lord, no increment would be given because there is a substantial rise. So my case is not that, lordship, as I pointed out, I have been given, my lord, I have been placed in the higher grades, Your Lordship. First stage, second stage, my lord, I have laid down the charts. I have been given. I have been given the salary. I have been of the higher grade. I have been given. But when it comes to increment, my lord, that was not given. Lordship will kindly turn to the next page, my lord, 79933. Now, my lord, matter of increment, my lord, this relates to pay fixations. It comes, my lord, when the time of pay fixation. So, Lordship will see 7933, pay fixation formula. On the top, my lord, next page.
Yes, yes. This is 8A, no? 8A increments. Yes, this is 8B.
Pay fixation formula recommended by the 6th Central Pay Commission as accepted by the central government shall be adopted for teachers and equivalent positions in the library and physical education cadres. So as accepted by the central government, my lord, whatever has been accepted by the central government, my lord, that have been made into a rules. That is called, my lord, Central CCS revision of pay rules, my lord, which I have annexed. Lordship will kindly come to page 40. Yes. My lord, at page 54, Annexure 7, my lord. This is the relevant part of the rules. This is the explanatory parts, my lord, additional parts. Actually, the rules start from page 55. My lord, this rule may be called CCS Revised Pay Rules 2008. Now, your lordship, pay fixation formula come to the next page at page 56, Rule 13. Rule 30. Yes. Rule 30. Fixation pay on promotion on or after 1/1/2006. The case of promotion from one grade pay to another grade in the revised pay structure, the fixation will be done as follows. One increment equal to 3% of the sum of the pay band and the existing. My lord, this is how it is to be worked out. Now that has been provided. So, my lord, the scheme is very clear, categorical. For time being, if we forget also, my lord, the UGC rules, it is very clear and categorical, my lord, how it is to be done. As per the existing scheme accepted by the central government, my lord, central government, whatever accepted has been made into the rule, and these hold the field, 13. Now, your lordships, in the writ petition, if you are, my lord, just as an instance, I have cited one decision of the government of West Bengal at page 59, my lord. Page 59, my lord. So this is the government of West Bengal's branch, etc., my lord. They have granted the UGC scheme following UGC pay scale following the scheme, and the relevant part is at page 62. My lord. Paragraph 8. Fixation of pay on promotion placement on account CS benefit on or after 1/1/2006. In case of promotion placement upgradation from one academic grade pay to another in the revised pay structure on or after one, the fixation of the pay of an employee will be made in the following manner. One increment equal to 3%, the same thing what is, my lord, provided in the CCS pension rules. Now, if I can take, my lord, to the decision of the government of Meghalaya. My lord, that is at page 42. 23rd March 2010. Now, my lord, the relevant part, your lordship, other thing, my lord, it is not in dispute, my lord, they have not granted me UGC pay scale. These are all admitted. UGC is only reservation. What my learned friend is saying, that we have not taken a policy decision in the matter of increment. So far, pay scale is not disputing, so I will not trouble your lordship to take into those parts. I will come to the increment part, that is at page 46, my lord. Page 46, clause 3 onwards. No, my lord, sorry, I'll start from page 45, my lord. Page 45, paragraph 6. Rate of increment in the revised pay structure. Each annual increment shall be equivalent to 3% sum of total pay in the relevant payment and the AGP as applicable in the stage in the relevant payment. Now, your lordship, come to the next page. Number 2, each advance increment. We are not concerned, my lord, advance. Number 3, the number of additional increments on placement at each higher stage of AGP shall be as per the existing scheme of increment from promotion from lower pay scale to higher pay scale. However, in view of the considerable rise in the effective pay scale of the two bands, there will be no additional increment or movements from such to such. So this is ditto a reproduction of what is provided in the scheme without any deviation, my lord. So now they cannot say, my lord, partly what my learned friend is saying, the entire thing is not obligatory and ask, my lord, that will be a wrong submission to say. Ditto, they have reproduced this from the scheme. Now, your lordship, kindly come to para 8. Para 8. Fixation of pay on promotion placement on account of career advancement benefit on or after the. In case of promotion placement upgradation from one academic grade pay to another in revised pay structure on or after 1/1/2006, the fixation of pay of an employee will be made in accordance with UGC notification. Here the notification will obviously include the rules. There is no such notification for increments. This is provided. Now they have taken a conscious decision, my lord. In the forgetting for time being, my lord, whether my lord implementation of the scheme would amount to implementing all the requirements laid down there without going into it. By this resolution, they have taken a conscious decision when it comes to increment for placing in the higher academic grade pay, my lord, they would follow the UGC notification. Obviously, my lord, notification include rules. Now they cannot say. Now, admitted position is this, my lord, when this resolution was issued, the UGC regulation of 2010 was not holding the field. It came thereafter. But that is obviously because in the scheme, central scheme also says that this is to be implemented strictly following the provision laid down in the scheme and UGC regulation to be notified. They have used the future tense. So here also, my lord, similar thing, because my learned friend raised an objection, we are not bound by it. Because when we issued this resolution or order, the UGC regulation of 2010 was not notified. So, my lord, that is absolutely a wrong submission, my lord. They were conscious about it. Central government also, my lord, in the scheme provided, used the future tense. Here also, my lord, they have followed the same. So, my lord, the other contention raised by my learned friend, and he cited a decision, the Vijay Gupta, cited a decision, my lord, Vijay Gupta, Vijayan, my lord, Dr. J. Vijayan, my lord, that case he has referred to. Now, my lord, this is, my lord, pertaining to superannuation. My lord, I looked into it. There was a problem, my lord, when this scheme was implemented by the state government, because the retirement age for the central university and other institution maintained by the UGC are different, higher, I think, yes, than what it is in the state. So that was a huge problem. Now, going by this scheme categorically say this is obligatory. As a, they're repeating the word, even the Supreme Court has to repeat this word as a composite scheme. You cannot escape. All you will have to follow. Now, what happened, my lord? These issues came up before various high courts, particularly in Kerala. Number of petitions were filed on the ground that since the scheme has been implemented in case of state colleges and deficit colleges, our superannuation is required to be raised and brought at level with that of the UGC or central government. That was the issue. Now that issue ultimately came before the, my lord, somehow reached Supreme Court. Now, This is the case, my lord. This will set at rest all confusion, my lord. If your lordship, now here it what happened, my lord. Supreme Court has referred to the power of the UGC, my lord, particularly section, my lord, 20 and 26. 20 and 26, my lord. I have just, that book is there. 20 and 26. Now this is very interesting. 26, my lord, empower the UGC to formulate rules. 26. Empowers, my lord. Empowers, my lord, 26, empowers the UGC to frame rules, my lord, to formal raising the standard of educations and all, my lord. I'll just read it out. Section 26. The Commission may, by official gazette, consistent with the Act and the rules made thereunder, regulate the meeting of the Commission. C, my lord. Specifying the terms and condition of the service appointed by the commissions. Then, my lord, specifying the institution or class, defining the qualification, define ordinarily to be required by any person to be appointed in the teaching staff, defining the minimum standard of instruction from the grant of degree in university. Now, my lord, next page, G, regulating the maintenance standards of coordination of work facilities in this same. H, regulating establishment of institutions. So, my lord, these are more or less, my lord, all relating to, my lord, some are relating to the condition of service, some with regard to, my lord, maintaining the standard of education. Now, they have the power. Now, your lordships kindly come to 20. Now, 20, what it say, my lord, basically, I'll just read this. 21, lordship has got it.
Yes.
In the discharge of the function under the Act, the Commission shall be guided by such direction on question of policy relating to national purposes as may be given to it by the central government. Number 2, if any dispute arises between the central government and the Commission as to whether a question is or is not a question of policy relating to national, the decision of the central government shall be final. So here they are saying, my lord, whatever be their rules, this should be in consonance with the decision taken by the central government. Even if they make a rules, my lord, if it is in conflict with the central government decision, my lord, central government decision will prevail. And here, my lord, these will come. Now what happened, my lord? As per the rules, superannuation age was different than that of the state government. So, my lord, these created a lot of problem for the state government. They have approached MHRD. My lord, considering the local condition, they sought for an exemptions. And ultimately, your lordship, in this decision, my lord, paragraph 7, I hope tell this.
This decision?
Paragraph 7 of this decision. What was the decision? Vijay Gupta. You have referred to.
Bharat Kumar.
Dr. Vijay. Paragraph 7, my lord. Lordship has got that. This one.
Yes, referring letter itself.
I'll just read it. It's paragraph 7. That question came. The government of India through the Ministry of
Which judgment reading? 2007, volume 11.
2000. This is 2022.
Okay.
SSC online 958.
Okay.
Paragraph 7.
The government of India through Ministry of Human Resources.
Yes. The government of India through the Ministry of Human Resource Development brought out a circular dated 14 August 2012 under section 20 of the UGC Act, paragraph 4 and 5, whereof read. 4. After taking into consideration the views expressed by several state education ministers during the conference held in 2010, the central government has now decided to delink condition of enhancement of age of superannuation from the payment of central share 80% areas to the state. B5. Bearing in mind the question of enhancement of age of retirement is exclusively within the domain of the policy making power of the state government, the issue of the state of age of retirement has been left to the state government to decide at their level. The condition of enhancement age of superannuation is 65 years, as mentioned in Ministry's letter dated 31/12/2008, may be treated as withdrawn for the purposes of seeking reimbursement of central share of arrears to be paid to the state university and college teacher. However, the other conditions mentioned in the letter cited above shall continue to apply. So, my lord, there was a conscious decision from the central government withdrawing the requirement of following, my lord, the age of superannuation, my lord, as prescribed in the scheme. Now, my lord, next, my lord, in this case, my lord, this question came when the rules provide a particular age. Then the Supreme Court has referred to 20 and held that since the central government has taken a conscious decision, my lord, this will override. This is mentioned in paragraph 8. Next paragraph. The UGC regulation had to be consistent with the decision on question of policy relating to national purpose, as may be given by the central government as per section 20 of the case. In case of any dispute between UGC and the central government as to whether the decision in question of policy relating to national purpose, the decision of the central government prevails over the UGC. My lord, that is how, your lordships, this has been withdrawn. And so there is, my lord, no question of following the, my lord, age of superannuations. Now, your lordship, coming back to the, my lord, increments, my lord, there is no such exemption granted by the central government. No such exemption granted by the central government. Rather, it is clear and categorical how it is to be calculated, how it is to be fixed, my lord.
Another thing, now you're arguing the whole matter again. What I'm saying is this: what about the objections he's made with regard to delay, with regard to non-joint and same parties?
I thought I only refreshing. I thought of, my lord, after the submission, he, my lord, tried his level best, definitely, very seriously, my lord, all the decision, everything. So I don't know, it came to my mind, I think I need to refresh. But it seems my lord is already jotted down the points and this is clear in your lordship's mind. But anyway, so far this judgment is concerned, my lord, I think this has been very clear and categorical.
What about the other judgment, 1007, 11 judgment, para 14?
Para for what is this?
Yes.
This is whether you can follow
that. Para 14 of the judgment, 1007, 11 judgment.
2005
lines on the bottom.
Para 14, my lord. Again, even if the state government accepts the part of the scheme, it was not necessary that all the scheme as it was had to be accepted by the state. In fact, the subsequent development suggests that the state government has not chosen to accept the scheme in full, as much as it has not accepted the suggestion on part of the UGC to accept of the age of superannuations. My lord, this is a judgment of 2007, my lord. This is obviously, your lordship, relates to the scheme, my lord. Relates to the scheme. Earlier schemes, my lord, may be, my lord, coinciding with the 5th pay commissions.
What about now? What about this current situation on the ground now, Mr. Sen? Now we already know this is the 5th pay commission, right?
No. Now we are on the 7th.
Now we are on the 7th. What's happened now?
2018.
7th will clinch the issue. I have the door. 7th will. They are giving me, my lord. I think my learned friend is not well instructed. They have given a letter so far, my lord. I'll come to that. I'll come. 7th pay, what is happening. Now, my lord, so far this is concerned, my lord, these pertaining to the scheme, my lord, not this scheme. Coinciding with the scheme of, my lord, after following the, my lord, 5th pay commissions. So 5th pay commission and this commission, my lord, all totally different. And the reference to the, my lord, this particular scheme, my lord, following the 6th pay commission, the position of law has been clarified by the Supreme Court decision, my lord, rendered in that Vice Chancellor case in Gujarat University case.
So you see this scheme is different.
This is different, your lord. This is not relating to, my lord, this scheme.
If my lord goes to the condition, my lord, you will see that it is the same, my lord.
This is not related
conditions of how the fund is to be given by the central, how the UGC fund will come, my lord. All other conditions is the same, ditto, my lord.
My lord, this relates to 5th pay scale.
Naturally, my lord, time to time, as the pay scale comes into existence, my lord.
My lord, this position, my lord, the language, then, my lord, the language of this other earlier scheme and the language of these schemes, my lord, they are not similar. That, my lord, pertains to the human resource letter dated 27/7/1998. Then 27/7/98, and my lord, the scheme formulated by Government of India, my lord, dated 31/12/2008. They are not same, because I am relying on the, my lord, relying on the scheme formulated by letter date in the letter date.
No, he's talking about analogy.
Analogy.
Like
How can it be analogy?
Whether like
scheme at that point of time, that was not mandatory. That was not mandatory. But the scheme now, present scheme is very clear. They are repeating composite. You cannot deviate. Even when the superannuation age was withdrawn, again they say, as regarding other condition, you cannot deviate. So, my lord, equating with an RDS scheme, my lord, which is altogether different, my lord, that will be, but this not relates to, my lord, the RDS scheme.
This is not applicable at all.
This will not apply, your lordships. Because otherwise what happens, my lord, these will be directly in conflict with the judgment rendered in that Gujarat case, which is based on the scheme formulated by the letter dated 31/12/2008.
Excuse me.
That is, my lord, again, I will not, my lord, waste your lordship times. I have referred to paragraph 27, 28, 29 and 50. That 2022 5 SCC 179.
Yes. Gambhiradhan.
27, 28, if your lordship wants, I'll just read it once. My lord. Paragraph 27. My lord, from 20, I read most relevant is 28. In the present case, the state of Gujarat has adopted the scheme of 13/12/2008. It is the same scheme pertaining to, by a resolution dated 11/11/2009 with effect from 1/1/2000, subject to the condition mentioned in the said resolution. Even in the said resolution, condition number 30 provides that the state government will publish the educational qualification as per the UGC instruction published from time to time. The resolution will have to be implemented. 29. It is not in dispute that SB University is receiving the central financial assistance under the scheme, and it is included that the state university is receiving central assistance as per UGC Act. Therefore, having adopted the UGC scheme and implemented the same and getting central financial assistance to the extent of 80% of the maintenance expenditure, the state government and the university are bound by the UGC Regulation 2010. The UGC Regulation 2010 are superseded by the UGC Regulation of 2018. However, the eligibility criteria for the post of Vice Chancellor and constitution of such committee for appointment of the Vice Chancellor remain the same. Therefore, the state government and the universities thereunder, including the SP University, are bound to follow the UGC Regulation 2010. So, well, very clear and categorical here. Now, my lord,
that's it.
For a moment, no, your lordship, I'll have to technical objection. For
That's
a moment, now, for a moment, your lordships, what my learned friend is referring to the 2007, which relates to altogether a different scheme.
1998
lordship. So that will have no application. Now, with regard to the scheme of 2010, my lord, the 2020, just now the decision I have referred, my lord, this is the relevant decision. This is very clearly and categorically stating this is binding. Now, my lord, just an alternative submission. An alternative submission, if your lordship permit and me. For the second, if your lordship assumes that this decision 2007 referred by my learned friend will have some bearing, my lord. But even then it's not going to help him. Why? As I have just pointed out, the order adopting the scheme by the state government in paragraph 8,
very clear.
Very clearly they say in the matter of increment for placing in the higher academic grade, we will follow UGC notification. So even then, my lord, it's not going to help them.
I will come to the technical objections now.
Now we'll go to it. I think I have to refresh your lordship's point. Now, my lord, screw your lordships. Give me this affidavit. Now, his first objection, your lordships.
Delay.
Delay. I'll start with delay then. Now, my lord.
He has 4 objections. One is delay. One is single petition. Third, non-joinder of the 3 parties.
Yes.
And fourth, you have not given any computation with regard to what are your entitlements.
Welcome.
As a 4, I think those are 4. Yes.
Yes. Now, Your Lordship, if I can take my lord the chart, when we were given the benefits, 16. Page 16, I have laid down the table.
Of your writ petition?
Of the writ petition.
Okay.
Now, my lord, first stage 1 to stage 2, writ petitioner was given the benefit with effect from 1/8/2011. Then,
one second. This notes are going all over the place now. Because if once you know the hearing, it doesn't go in one day.
That's the problem.
Some page they are missing from the one hearing. I did the entire my notes were missing when I went to dictate it. Now where are we? Yes,
page 16. Now, writ petitioner 1/8/2011 from stage 1 to stage 2. Now, writ petitioner number 2.
One second. 16, page 16.
Page 16, my lord.
Yes.
Now, my lord, 1/8/2011. Then, my lord, second writ petitioner, he has given this benefit from 16/4/2013. And the third writ petitioner given this benefit from 1/6/2014, your lordships. Now, my lord, first thing, your lordships, this is a statutory rights. Because this appendix, this scheme, whatever is central government scheme, that has been appended.
You're replying on delay now.
Yeah, I'm replying. This has been appended to the regulation of the UGC. Regulation of the UGC. So, my lord,
is a continuing right.
Yeah, once it is, my lord, provided by regulations and it became part of the regulation, there is no question of waiver, acquiescence against the, my lord, a statutory right. Even if I am not asking for him, it is his duty to give me. But here it is not the case. Here what happened, your lordship, we filed several representations. But again, my lord, filing several representations that may not condone delay. But they have ultimately, when they have acted on it. What is that? Communications. My lord, if I can take your lordship, there are several representations, my lord. All the representation I have not annexed. The representation I have annexed, of course, of 7th February 2020, my lord, annexure at annexure 10, page 65. Detailed representations. Now, my lord, ultimately, my lord, the respondent have acted on it. It's not that they have not acted on it. They have acted on it, my lord. And that communication is at annexure 11, page 75. Sorry, my lord. That is at page 85, annexure 12. Page 85, annexure 12.
Yes.
Lordship. Now it will serve two purposes, my lord. If I can read the opening paragraph.
It's not an answer to your.
No, my lord. What I am saying, one. This is a continuous wrong. A statutory right, there cannot be waiver and acquiescence against statutory rights, so that the question of delay will not come. And otherwise, also I am saying there is no delay in filing the appeal. I filed several representations. Some of the representation I have annexed here with, my lord. And then there was a communication based on those representation, my lord, by the Joint Director, Higher and Technical Educations. And this is a communication, my lord, from addressed to the Joint Secretary to the Government of Meghalaya, my lord. Now, what it say, your lordships? It say, my lord, it has referred to the various paragraph of the scheme contained in that letter dated 31/12/2008, and then ultimately held, my lord, your lordship, come to page 86 in the bottom. In view of this, directorate is that the teachers are well within their rights to point out the anomalies so described above, since while extending the UGC pay scale, it seems that pay fixation formula also needs to be followed in totality. In view of the above, government is requested kindly to extend the promotional increment while promoting the teachers of both college and deficit college from such and such. So my lord, it's very clear. Government has taken action. This has come none other than from a joint directorate. He said following the various paragraphs, we are entitled.
That means that the delay is gone.
What, my lord? I came on 22.
They've already taken a decision, and so representations dated when?
Some of the representation, that is of 20.
Dated when?
20.
2020, my lord.
2020. 2020, my lord. But then they have acted on it.
Okay.
All right.
Next
if
point.
they were really serious about it, my lord, delay, which they could not have, my lord, statutory right,
Yes.
they could have said, we will not look into it. It's already barred in that communication. They would not have made communication.
Yes.
Instead, they have made a recommendations that they are entitled to it. And I filed this writ petition in 2022. Obviously, my lord, reason lordship is aware of the situation, my lord, 2021 situation that due
What
to
situation?
the pandemic, your lordship.
Oh, I already forgot about it, yes.
But the situation was such.
Yes, yes. No. Okay, delay may not be a point. Of course, you raised it. You have answered
there is
it.
no
Now
delay
next
as such.
next is on
non-joiner.
Yes, on no. Single petition.
Yes, your lordship. Now, my lord,
and being vague on a joint cause of action.
Yes, joint cause of action. Yes. That again, your lordship.
You have not given me why joint cause of action when your entitlements and whatever you have to release are separate.
Now, lordships, again I will take my lord to page 16, my lord, the table. Now, my lord, our only grievance before your lordship is, we have been placed in the higher grade from writ petitioner 1 and 2, my lord, from grade 1 to grade 2, then, my lord, from stage 2 to stage 3. So, for the writ petitioner number 3 is concerned, he has been placed from stage 1 to stage 2. Now, our contention is this, on such placement to higher grade, we are entitled for increment as contemplated in the scheme. Well, this is our
3% of basic.
Yes, my lord. Our contention is that as per the scheme, we are entitled for the increments. Now, suppose for a moment, your lordships, all our grievance and right is based on that scheme and subsequent regulation formed by the university. Lordship will think for a moment. So only issue to be decided here, what is the issue? Are we entitled as per the scheme and the regulation frame thereunder or not? So my lord, here the issue is a common issue. If the movement is from one grade to another grade.
Why vague? The thing is that now you were all put in this grades at different dates, correct? Now you have to compute as to what will be entitlement. Because your basic case is that there's no question of disputing the applicability of the scheme. Correct. After 2008, 2010, there's no question of disputing, and the government, by its own policy decision in that letter dated 2010, has categorically said that that increments will be applicable. Paragraph 8. Okay. Now, when you come to individual cause action, means that you have to quantify as to what reliefs you are to entitled by the petition. By not saying that the implementation is doubtful, by saying that implemented, and this is what I am entitled to from the date from which I have placed in this grade. That is what Mr. Parasaj is saying, that is vague now. Is vague now. You're asking for a general thing, which the reliefs prayed are vague in the sense that, and then you've come by a joint petition. Yes.
Okay, I'll answer that, my lord. Now the question of these comes under what your lordship is, what will be the quantum? Right?
What is the individual right?
Yeah, what is the quantum?
Which is quantified in terms of money.
Exactly. 3%
entitlements.
Now, my lord, this is to be done by, so far this is concerned, this is to be done by an authority call, and they have admitted their petition, affidavit. That is an authority call, my lord. Directorate of Local Fund Audit, State of Meghalaya, Shillong. They are the party respondent number 6. And what they have stated in their affidavit, first affidavit, my lord.
Now, single petition. Yes, okay.
Yes. Now, my lord, will come to the first affidavit filed by them, original affidavit filed by them, at page 6.
First affidavit, both the affidavits are filed by the Education Department.
No, whatever it may be, whatever their contention they have raised. Lordship, if I can read this paragraph, my lord, these paragraphs are very long. Page 5, my lord, from the bottom.
First affidavit.
First affidavit.
In this regard,
Lordship. In this regard, it may be appropriate to mention herein that as per the usual norms of the practice, as per the fixation of the influence were normally being done by the respective colleges, and the same are thereafter sent to the government for approval. Now they have changed the situation. But in the recent times, certain objections have been raised by the Directorate of Local Fund Audit fixation as regarding such fixation, as some anomalies have been found regressive. Therefore, the Education Department along with the local fund audit are in the process of streamlining the matters relating to the pay fixation of the deficit college teachers. So they themselves are admitting, my lord, this is to be done by them, not by us. And no government employee, my lord, he calculate his things and go. It has to be normally fixed by the employer. So they have admitted here, my lord, this will be done by them, not even by the college. And these will answer, my lord, the other objection raised by my learned friend. Now, if the my learned friend has raised, no, this is to be done by the management, then yes, the question comes, why you have not made them a party? Relief is not possible without them. Now here they have admitted, my lord, who is to done the fixations. Management, college has no role.
Yes.
Now really, my lord, question of my lord, three petitioners joining, my lord. Here I said, my lord, all my claims based on that scheme and the regulations entitled for increment. There is no dispute in the bar, your lordship, that they have not placed me in the higher grade. They have placed me in the higher grade, but they have not paid the increment. So my entire thing based on that scheme and the regulations. So here your lordship is to answer a common question of law. Are we entitled under the scheme?
Order
Is
one.
it binding?
What is that provision CPC?
What?
Was the provision CPC?
Yes, my lord, I'll say that. I'll say that. So my lord, what happened? If I had filed separate petition, lordship would have clubbed them together and answered it by a common judgment. Now, my lord, this is Order 1, Rule 6.
Yes, A. I'm not wrong.
Order 1 rule. This one? Rule 6. My lord. Lordship, my lord, Order 1, Rule 1. Who may join as plaintiffs? All persons may be joined in one suit as plaintiffs where A.
Common cause of action.
Any right. Lordship has got the book.
No, I don't have the book. I'm just recalling from memory.
Lord Lordship. Any right to relief in respect of or raising out of same act or transaction, series of act transaction, but these will not apply. B, my lord, it's important. If such person brought separate suits, any common question of law or fact would arise. So here exactly the same situation. If I have filed 3 writ petition, lordship would have been called upon to answer whether they are entitled for increment as per the government scheme adopted by the state of Meghalaya and the consequent, my lord, UGC regulations. So, my lord, technical, it's true, your lordship. That day, your lordship also said technical objections, all right, my lord. But he simply said, raise these technical objections. How it has been prejudiced, he has not uttered a word, your lordship.
No, it's not kind of prejudice. Technicalities are there which have to be, answered. The thing is that technical objections can be there. Sometimes on technical objection, the objection will fail.
Exactly, my lord, that's true. So, my lord, here I am answering, my lord, I have done it.
So you say also UGC is not necessary party.
That I will also come, your lordship. That I will come, UGC. Now, my lord, coming to UGC. Now, my lord, I have read out again, your lordship, the government of India's MHRD scheme, my lord, dated 31/12/2008. Now, this is, lordship will keep it in mind, this is a decision of the government of India. Funding by government of India. Decision by the government of India. And my lord, the exception created for adopting this, that is also by the government of India. Now, government of India, so far MHRD is concerned, my lord, I have made them a pro forma party. I have served a copy on them. Now, so far UGC is concerned, my lord, they are neither the funding authority, they only formulate the rules.
Even then,
My lord, formula, my lord, how it is, if it is prejudice anyway, my lord. Now what answer your
Suppose we seek some clarification.
Clarification to what, my
with regard to the implementation other states, and and with regard to whether it can be where it's happened anywhere, where there's been a piecemeal implementation and it's allowed.
Well,
what is the state seeking to do? The state seeking to piecemeal implement the scheme.
Cannot be. My lord, that depends on the scheme.
So UGC cannot answer that.
My lord,
we have no question.
No, UGC can. What happened in that doctor?
Can't UGC sort of buttress your case?
No, my lord. Here, what happened just now? That decision of 2022, referred by a learned friend. What did it say, your lordships? My lord, so far UGC is concerned, my lord, they are guided by the decision taken by the central government. They cannot override. That power is not there. There, what happened? Superannuation age change was brought by the central government. Then they said under 20, if you are in conflict with the central government, the decision of the central government will prevail.
Yes.
So here I am concerned, entire foundation of my scheme is on that scheme.
On central government letter.
Central government letter and scheme. Here what is, do I have, my lord, for the sake of convenience, my lord, some of the queries answered by the UGC, your lordship. I have an act. Now, UGC cannot come tomorrow and say, no, state is at liberty, my lord, piecemeal level. They have no authority, your lordship. MHRD, yes. That's why I made them a party. Served a copy on them. But anyway, they have not responded, nor they have appeared, your lordship. So
They've been served.
I have served, your lordship. Served a copy, but they
Who
have
appeared
not.
for them initially?
Nobody appeared.
Nobody appeared. It's been served.
Yes. I think it will be there on the reports. The copy has been served. So it all decision of the central government. Now UGC cannot override. UGC is nobody, your lordship, except that rules. Now UGC rules all are in consonance with the scheme. And further, the scheme has been appended as Appendix 1 to the regulations. So my humble submission, my lord, presence of UGC will, my lord, have no effect in this case, your lordships. And they are not an authority to answer whether piecemeal or not piecemeal. It is central government only, your lordship. And central government has made it very clear and categorical, your lordship. And as reflected in the recent judgment also, your lordship.
You mean to say they are not necessarily party, they may be necessary, they are not even not necessarily a formal party also.
Well, they are not required, my lord, because in view of the fact, my lord, is the scheme of the central government. And scheme of the central government, my lord, central government has directed UGC. What it directed? That you should formulate regulation in consonance with our scheme. And that decision of the Supreme Court is say, my lord, if it is in conflict, my lord, the central government decision will prevail. So, my lord, even if UGC is a party, my lord, they are not in a position to say whether it is piecemeal or not in a piecemeal. And even if they say it can be a piecemeal, my lord, that will be in conflict with the scheme framed by the central government.
What's the ministry called? Human Resources and Development.
Ministry of MHRD, my lord.
But now I think then one pleasure has changed.
Now,
Ministry of Education.
Now it's MOA, my lord. Ministry of Education.
Ministry of Education. Now, my lord, other thing, your lordships, my learned friend, I don't know, lordship, kindly, if I can, my lord, trouble your lordship to take back to that table.
Page 16.
16, my lord. Lordship, I can take back to page 16, my lord. Now, page 16, my lord. Lordship will see, my lord, stage 1 to stage 2. All the writ petitioners, they got
what
it.
question answering here?
My lord, here, my lord.
Common cause action.
No, not cause of action. My lord, joint
petition.
No, that I have answered.
So why you coming back to
this is it. Because what happened, my lord, in the meantime, Lordship also asked me, 7th pay commission has been accepted, and this came into effect from 1/1/2016, if I am correct. 1/1/2016, my lord, came into effect. 1/1/2016. Now, your lordship, look into the table from stage 1 to stage 2 and look into the date. These were all before 1/1/2016. That means they would be governed by whatever scheme, regulation, my lord, following the 6th pay commission.
No, see, one is, because this is from 2006, correct?
Yeah, 1/1/2006.
6 to 10. That was 6 to 10 was to be funded by the central government.
5 years. That's
5 years. And then the next pay commission came into force
in 2018, my lord.
No, 1/1/2016.
2000.
10 years, 1/1/2016.
My lord, the regulation is of 2018, if I'm not mistaken, my lord.
Regulation comes afterwards, my lord. Always they use the future tense. They say to be formulated by regulation.
So what
It will be based on the regulation.
No, my lord, what I want to point out from here, now on and after 1/1/2006, whatever increment, I mean, whatever, my lord, placement is there, my lord, they would be governed by the decision taken following the 7th Pay Commission. Now, my grievance is, my lord, prior to 1/1/2016, my lord. Prior to 1/1/2016, means, my lord, stage 1 to stage 2, petitioner number 1 was given 1/8/2011. That is under 6th Pay Commission. Next is, my lord, 13, that is also under 6th Commission. 14 also under 6th Commission. Now, my lord, stage 2 to stage 3, my lord, obviously, my lord, 16 and 18, my lord, all after 1/1/2016. Now, what will happen? These will be taken care by whatever recommendation has been made under the 7th Pay Commission and accepted by the Government of India and the UGC, your lordship. So my concern is only with from stage 1 to stage 2 affected prior to 1/1/2016. Now my coming to, my lord,
yes,
increments under the 6th and after the, my lord, 7th Pay Commission. Now we have applied to the government under RTI what they are doing. They have admitted we will give you increment. We have worked out how increment is to be given. So, my lord, my grievance is not with regard to those increment given after 1/1/2016, only prior to 1/1/2016. Give me one copy. This is, my lord, 26th July, right to information. So, if I can
Not a
read
part
it.
of record, my lord.
That you can, lordship. With reference to the letter number, the subject cited above, I am to furnish here with the replies of the RTI application as her. On being promoted, this is with reference to a particular teacher, from stage 2 to stage 3, from level 11 to level 12, with effect from 2022. The pay will be fixed at 2,500 per month, that is 87,000 plus 2,600 national increment, equivalent to 89,900. Next higher pay level 12, rupees 92,500 per month, September 22, with date of next increment on 1/7/23. Now, your lordships, there seven.
Who is this barometer, Nongri?
It is not the petitioner, my lord.
My lord,
Some other person.
I'm just citing an instance. Just citing an citing.
Barometer.
This is not a part of record also, my lord.
Just citing an instance, my lord, what they're doing. Because so far, my lord, because I am not concerned, because they are, I have the instruction, so far, my lord, those increments after 1/1/2016, my lord, government is taking care of.
You have no quarrel with
No, my lord, no quarrel. I think you should have been better instructed, your lordship. It's not for the sake of opposing. Otherwise, I would have said, give me relief with regard. Why I am not saying? Because my client has instructed me.
On how many teachers are there throughout the country or throughout the state?
Lordship.
Who have been covered and
No, these also I got. I'll come. I'll come.
Instructions I don't have, my lord.
Now, my lord, 400. Now, my lord, coming back to lordship has one thing in mind: financial implications. Very meager. Now, my lord,
meager for three of you. What about entire cadre of the entire state?
I'm coming to that. Now, it's hardly 400 rupees one increment. If your lordship includes average, includes the area, it will be a little over, my lord, 2 to 3 lakhs. 2 to 3 lakhs. Now, coming to the, my lord, number of government colleges. How many government colleges? Now, number of government colleges are very less, state of Meghalaya. If I am, my lord, correct, in Shillong, we do not have any government colleges. I don't know the status of Commerce College.
What about the teachers who are paid in this the state scale in the private colleges, in the other colleges?
Not deficit.
That's a deficit grant, my lord.
But deficit grant,
yes.
The number of deficit colleges are more here.
They
So
more,
all-
but
no,
they are being paid this scale only.
Exactly, my lord.
Yes, that's what I'm saying.
So government colleges, you leave government college, whatever it is, whatever is.
I don't know whether they have received. I doubt.
They receive because in every college there's those are getting the UGC scale.
Yes.
And are getting college pay.
No, I'm saying suppose.
And the other teachers are paid by the governing body. There are three categories.
So, my lord.
So those who are getting UGC scale by the state government, then they also will be impacted. They will be getting the arrears also.
Obviously, my lord. But even if your lordship will look into the areas, it's not going to be a my lord, huge amount. It's not correct. As I said, my lord, in our case, it will be around my lord 2 lakhs.
So for you, yes, for you, you're just one people. What is the entire cadre? Must be huge.
No, entire cadre, my lord, this is only for the period. So far the period is concerned 1/1/2006 to 1/1/2016 for that period, your lordship.
I just want some. What about those teachers who paid UG scales in private colleges like St. Edmunds, St. Anthony's? They paid UG scale. They paid by the government.
Paid by, but
they paid by the government.
These are deficit colleges.
But this is the UG scale they're getting.
Colleges,
deficit. They're not deficit. They paid that. They have that. What do you call it? Deficit grants and aid, whatever.
Deficit grant, salary grant.
Yeah, salary grant. So what is the implications on those lecturers or on those assistant professors and associate professors?
If it is a deficit, they will be entitled.
They'll be entitled, of course. That's why what is conscious about, that in view of, this petition, it'll be allowed, suppose it's allowed, then no preconceived notion like earlier.
But if there is a breach of law, forgetting about the other consequences, that cannot be.
That cannot be consideration.
But if there is a breach, if there is a breach, Red Court will enforce it.
Yes, right is right.
Enforce it, my lord. But still, I am trying, my lord. My understanding, my lord. Ultimately, if all the teachers they make their claim, my lord, it will not be more than 2 to 3 crores rupees. It's not initially. I also thought, my lord, it will run into under 30, 40, 100 crores. It's not like that.
Possibly,
but it's not like that, your lordships. So my humble submission, my lord, if there is a breach, that has to be enforced, your lordships.
Yes.
Immaterial, my lord, what are the other consequences?
That's all.
No, anything?
Yes.
Nothing. That's all, your lordship. Deficit. My lord, just some statistics, my lord, for your lordship appreciating the facts. Now, the total strength of the deficit teacher across the state, my lord, will be 600. All of them are not eligible. Out of this, my lord, hardly hundreds are eligible.
You can't say that anyway.
Anyway, so what I am saying, my lord, we have made some kind of calculation. It's around, my lord, hovering around, my lord, 2 to 3 crores rupees. So it's not a huge amount. Had it been so in the original affidavit, they would have said this implication is huge. They have not said anyway in the affidavit. But in the first hearing, your lordship has pointed out this perhaps will have a financial implication. Then in the second affidavit, my lord, very vaguely they said these will have some financial implication. Now, what is the amount? They could have said, my lord, if you do it, it will run to 100 crores. They are not saying.
Yes. Right. Any reply?
My lord, I wanted to reply, my lord. I wanted to reply actually.
Yes, you reply.
My lord, on one hand, my lord, my senior has relied on the first affidavit, my lord, where it is stated that there are some issues with regard to pay fixation, my lord.
Yes.
But on the other hand, my lord, because the same affidavit we have stated, my lord, that whatever is the petitioners are entitled to, it's already been paid to them. Our first affidavit was that, my lord, that as per their entitlement, they have received whatever their salaries or whatever due amount was there, they already received it. This was the first stand that we had taken. Some anomalies with pay fixation, well and fine, my lord. But when it came to the case of the petitioners, this is our submission, that from stage 1 to stage 2, or whatever stage they went, my lord, whatever as per their entitlement, they got it.
You mean do you already paid in increments?
Yes, my lord, as per their
Where's the
entitlement.
hard facts on that?
As per their entitlement, my lord. Now, as far as the calculation is
saying, my lord, there is no policy decision on the increment.
My lord, our affidavit says as far as
all
our...
that he has argued all through.
My lord, as far as the scale of pay is concerned, which is given in the table 1, my lord, appendix 2. So, as per the table, my lord, they have been paid.
I'm only concerned with the increments.
Now, increments, my lord, the petition...
Increments inclusive of the pay that they've been getting?
Exactly, my lord. Whatever
But
is
they have
entitled.
not come with any, they're not even given the pay scales.
Exactly, my
in the
lord.
petition.
That is exactly why the petitioner, assuming that petitioner has no knowledge, but they could have had some, they could have given some rough computation as per their understanding, my lord.
But, Mr. Secretary, provide that because before we generate the judgment.
Lordship regarding?
The pay scale, what they give drawing during that time where there's no element of increment.
Exactly. They have not given
How
any
much,
pay
you've not given how much you drew also at time, there's no increment.
They
How much
have
you're drawing
so
post
far, my
16.
lord, all throughout what he is arguing.
No, you see how you craft represents that after 2016, now you're getting the increment that should be included like before for that gap.
No, they have made it. I'll just come to your lordships. Where is that increment?
Where in your petition you said? That's why he said, why did Mr. Barachit say is vague?
Lordship.
That's why he is vague on computation. Where's the revised, where
My lord, if I take my lord to table 1, now grade, academic grade pay, it says 6,000. My lord, we have given 6,000. We have also stated in.
Or was struck off the Union
we have
of India?
also stated, my lord. Stage
Why
1
was the Union of
SS
India
supervisor.
struck off?
Lordship.
This scale of pay we are giving.
Where?
My lord, if my lord goes to table 1, which is appendix 2, my lord.
No, coming to the writ petition.
My lord. They have not given any computation. My lord.
Two pay bands, 15,600, 37 so and so. Which I carry paid. Okay, that's then that's in para 2. They have not said anything about how much they're drawing.
My lordship will come to this.
Para 6.
Para 6. What are the, because increment with higher grade. Now higher grade, my lord, I think detailed submission I have made, your lordships. You start from 7,000, 6,000, initial entry 6,000. I think I have made my submission, my lord. 6,000, then 7,000, then 8,000. So these I have categorically I have stated herein. And he is admitting that we have been placed in 7,000 to 8,000. So moment you plead me from 6 to 7, there is a case of increment, additional increment. My grievance, though I have been placed in the higher grade, but I have not been given the increment. I don't know, my lord, where is the confusion here?
Okay. Yes,
where is the confusion here? Stage 1 to stage 2. That means, my lord, if your lordship go into the table, again I have categorically stated. Stage 1 to stage 2 means what? 6,000 to 7,000. Why is confusing the code? I could not understand. 6,000 to 7,000. Then, my lord, stage 2 to stage 3, 7,000 to 8,000. So, moment I place, my lord, from 6,000 to 7,000, I am entitled for an increment. How it is to be computed, my lord, under CCS rules, 3% and all. That they themselves are admitting they have taken up the exercise. Now he is saying we have paid. Well, this kind of submission, just for the sake of submission, should not be made.
Yes.
My lord will kindly see. My lord, as far as the salaries are concerned, my lord, the petitioners have not given what is the current basic pay or what is the current pay structure they are having.
No, how it has
Never. My lord, why not, my lord? Petitioner is only harping on, my lord, stage 1 to stage 2 this much.
There is what they say about stage 1 to stage 2, there will be an
my lord, what is fine, my lord? No, my lord, if we go back to the scheme. Now, the very heart of the scheme, my lord, is the finance from the central government. This is the very heart of the scheme. Today also I have verified, my lord, whether there was any reimbursement from the central government. They said no. The very hard. So that means we are in a situation, my lord, that we will not get any central government fund.
The thing is that you implemented it,
my lord.
Right? 2006. You paid them the pay fixation as given by the scheme.
My lord.
Correct. But the only components the payment didn't give. Now the thing is that you were supposed to get for the first 5 years. You didn't avail of that. How are they responsible?
No reimbursement.
How will they be responsible for that?
My lord, that is exactly what I am saying. This is a case where the state is funding the whole. Everything is being funded by the state. There is no central assistance. But the very heart of the scheme, my lord, the very heart of the scheme is central assistance. 80 by 20.
Very serious submission. They have implemented the scheme. They have not received the 80%.
80-20.
In the affidavit, where they have made this statement? That is very wrong, Your Lordships. This should not be.
Yes, my lord. In the additional affidavit, we have stated, my lord.
This hearing will never end now.
My lord, let it continue another date, my lord. I'll give my.
No, my lord. I think Your Lordship will conclude it.
My lord, I have actually, my lord, I had school duty, but still.
My lord, it's the last 4 months, my lord, these things are going on.
My lord, will kindly see in our affidavit we have stated categorically. My lord, it is at page 8. Page 8.
Affidavit.
Yes, my lord.
Yes.
My lord, I'll start from page 7, my lord. End paragraph.
I've not heard the matter for so long as I've heard this matter.
Huh?
My lord, it can be seen that the same does not speak of any increment. Of course, I have referred to the latest government letter, my lord.
They have not read it.
It can be seen that the same does not speak of any increment or additional increment. Further, it is pertinent to mention herein that the state government is not getting any salary grant either from the UGC or the MHRD. The salary for the teachers is solely being borne by the state and none other. It will also be apt to mention herein that the service of the deficit college teachers is guided by Assam Aided College Employee Rules 1960. The Assam Aided College Employee Amendment Rules 1973 and the management of the deficit school colleges, including release of salary grant, etc., as per the Meghalaya Deficit Aided Colleges Management Rules 2013. Hence,
are you positive about this that 80% in the implementation 2006 you didn't get any money at all?
I don't.
80%.
It's not categorical.
My lord, this is what we have. This is what the instruction that I have received, my lord.
We are talking about 80%. That 80% central government has not given.
My lord, what the letter says. My lord, will kindly what the scheme of the letter says.
He's saying salary grant. There is no provision for salary grant.
My lord,
they said 80% for 5 years.
Yes, my lord.
They should have specifically said that they have not given. Then why they have implemented it?
My lord, will kindly see what is the applicability of the scheme. The applicability of the scheme itself is clear, my lord. The scheme, this is applicability of scheme is P, and it comes from. I take my lord to.
Okay, we'll forget about that. You come. I'm afraid, but then court wants to know that part whether
80%.
Yes, that's
very
the thing.
serious thing, Your Lordship. Lordship can call some officer to file an affidavit in this case.
Well, let him come for instructions. If he says no, then
government of Meghalaya will forego crores of rupees.
5 years,
this kind of
80% of the burden,
my lord,
being not being availed of. That is
very serious.
You get instructions,
my lord.
We've concluded.
What is this statement, my lord? Salary grant. Why MHRD should give salary grant? They said for 5 years, whatever is the expenditure, 80% we will pay.
Exactly.
That is very clear and categorical. If he was so confident, he would have said that 80% we have not received.
Matter, Mr. Sen. It's only that what is the expenditure incurred,
my lord,
in implementing this scheme. For the first 5 years per scheme, 2006, 2010, it will be borne 80% by the UGC,
by the UGC,
UGC
by the
and
MHRD.
20% by the through the UGC, whatever, and 20% by state government. Now you say that from 2006 till 2016, now you've bonded single-handedly. That is your statement.
No, that was what I was informed.
Then
but
you
I'll
kindly
get
bring instructions.
I'll get clarifications.
This is not a clarification. This is a serious thing on these issues. You should file
Monday,
an affidavit.
by Monday.
You should file an affidavit.
Monday.
But so far,
by next Wednesday. This is matter on Wednesday for instructions.
Let him file an affidavit, my lord. That
No, he gets instructions first. See, once you file affidavit, suppose it's not correct, he gets clarification. Then also it call for affidavit.
Lord, pray for a week's time, my lord.
Okay, 1 week's time. The matter has been heard, and the matter was heard about to be concluded. Stop. Mr. Kimi Bhattacharjee, however, has made a submission that from the implementation of the scheme in question, there has been no assistance from the no assistance has been received from the UGC or central or the central government. So he's directed to obtain instructions as to the correctness of the statement. Yes. Very serious.
This is very serious, I think, my lord. Very, very serious. This is just not one
But it's giving you a good fight.
My lord, only thing this, so far this, my lord, hearing stand concluded.
How do you conclude it? We have to instructions. Can I pass a judgment and give a corrigendum to the judgment? Yes.
Obliged,